May I please, the Lordships?
Yes.
Lordships, I beg to mention item number 2, Lordships. Lordship, I have sent for vetting, Lordship, if this matter can come up after, on Friday, Lordship. On Friday, Lordship.
Lordship, it's a preventive detention matter and
This can be done only on 28th. Vacation means,
Lordship,
not Friday because perhaps division bench will not be available.
Lordship, the detaining authority has extended and which expires on 27th
No,
December. Lordship.
Friday division bench will not be available.
The Lordship may kindly accommodate tomorrow,
Tomorrow, Lordship.
subject to convenience of this.
Lordship.
Tomorrow.
Obliged. Hello.
As sought for by Mr.
Vijmomi.
Vijmomi, learned State Council, release the case tomorrow. Appraisement in presence of Mr. Muajami, learned counsel for the petitioner who has not objected to the same.
Much obliged, Lordship.
Obliged.
May I please, Lordships? Lordships, I beg to mention item 15, Lordship. For the appellant, make a mention of behalf of Mr. Taliao. Lordship, he has some personal difficulties, Lordship, so if the matter can come up after the
Okay,
winter break.
2024.
Lordships,
Mr.
15th.
Josego Kote, learned counsel for the appellant, has submitted that Mr. Taliao, learned counsel who is leading him in this case, has some personal difficulty today and has thus prayed for listing of the appeal after the ensuing winter vacations. MS V. Sukril, learned additional public prosecutor for the state respondents, and Mr. Z. N. Yuli, learned central government counsel for the respondents are present and they have no objection to have a prayer.
Highly obliged, Lord.
May I please, your Lordships? My Lord, topic commission item number 11. Let this matter become up other vacation matter.
I have no objection, my lord, yes.
Okay, Mr. A. Joe, learned counsel for the item.
11, my lord.
11.
Mr. J. N. Nguli, learned counsel for the learned central government counsel for the appellants, has made a prayer for adjournment. Mr. Ajo, learned counsel for the respondent, has submitted that he has no objection to the prayer for adjournment. As sought for by the learned counsel for the parties, raised the case after the ensuing winter vacation on a date to be fixed by the office.
Much of us, please.
Please, Your Lordship, I may be allowed to move an unlisted motion letter. I have held this morning. It's habeas, the petition is habeas corpus in nature.
Habeas corpus.
Yes, Your Lordship. Much obliged.
May I please, my lordship, I better mention item number 14. Lordship, I have some difficulty today, so if it may be listed after the vacation, lordship. I've taken the consent of the other party, lordship.
Appeal against acquittal. Appeal against acquittal.
Yes.
Conviction.
Conviction. Why state is preferring appeal?
No, sentence, on the sentence.
On the
lordship.
sentence.
On the sentence.
Yes.
Why?
Lordship, actually.
How much was the punishment?
10 years was awarded. Actually, he was convicted, he was acquitted under 302 and convicted under 304. So we're appealing against that. And even if he wants to be, the conviction under 304 is to be upheld, we are praying for enhancing the sentence. That is-
He is inside the jail.
Yes, yes, lordship.
Okay, Mr. KV Angami, learned public prosecutor for the appellant, has made a prayer for adjournment. Mr. Posego Kote, learned counsel for the respondent, who is present, has submitted that he has no objection to said prayer. As sought for by the learned counsel for the party, release the case after the ensuing summer winter vacation and date to be fixed by the office.
By your lordships.
May I please, Your Lordships. Lordships, I would to mention item 8, hearing item number 8. Lordship, I pray that let this matter come up after a vacation, Lordship.
Okay, on the prayer of Mr.
Nokle M. Konyak.
Learned counsel for the appellant, release the case after the
Lordship.
ensuing interrogation and date to be fixed by the office. Mr. Posego Kote, you are for whom?
For informant, lordship. That's number 2.
Learned counsel for the informant. Respond number 2 is present.
The prayer, Lordship.
May I please, Your Lordships? Lordship, I would like to mention item number 6. In this instant case, Lordship, I would like to withdraw this instant petition.
You're for 6, okay. You want
Yes, Your
to withdraw?
Lordships. Yes, Your Lordships.
Mrs.
Detention. She has been released.
No, Your Lordship.
Miss
Nancy Lotha.
Nancy Lotha, petitioner has submitted, on instruction, that petitioner wants to withdraw the writ petition. So stop, Mr. N. Z. N. Muli. And Mr. KV Angami, learned public prosecutor for the respondent state of Nagaland are present. In view of the submission made by the learned counsel for the petitioner, the writ petition stands dismissed on withdrawal.
Much obliged, Your Lordships.
May I please, Your Lordship? Lordship, I beg to mention item number 4, Your Lordship. I'm making a mention on behalf of the counsel for the petitioner, Pakin Richabo. Lordship, we have some personal difficulty today, Your Lordship. I've been informed that the petitioner are planning to withdraw the petition. So if this matter may come up after vacation, Your Lordship.
No, only because you were speaking, so it's good.
Of the petition is allowed, raise the case on 22
Lordship.
January.
Lordship. Much obliged, Your Lordship.
For admission, item number 1.
Yes, madam.
Yeah, please, your lordship. I'm appearing on behalf of respondent number 3. Lordship,
Exponent number 3.
we have received an additional affidavit that has been filed by the petitioner.
You received long back, I think.
Lordship, we have already received, Lordship.
Ah.
So as far as the additional affidavit is concerned,
Director, Department of Social Welfare.
Lordship,
Some non-compliance
no, Lordship,
are identified.
no, already filed, but as with regard to the latest affidavit, we have one letter from the ministry which has been issued in the dated 19/6/2024, which says that now henceforth, the food items that has to be distributed under the SNP, the said scheme, Lordship, it will depend upon the Aadhaar uploaded in the tracker. So suppose in a village, if there's 100 beneficiary, Lordship, if there's 100 children, if in the Pushan tracker only 20 is uploaded, then accordingly only 20 for the 20 only will be provided by the ministry. So that setting is going on, Lordship. That has been issued way back from 2021, but that has been the latest date is letter received is 19/6/2024, Lordship. So that assessment is going on, Lordship. So until unless the petitioners upload and upgrade their Aadhaar, then the sanction will not come from the ministry, Lordship. Unlike
It is
those
not
cases, Lordship.
petitioner, I think beneficiaries.
Lordship. So, Lordship, my only humble submission, since the petition is already complied, only the latest additional affidavit. So, if certain necessary direction may be issued, Lordship. It's a 2020 PI, Lordship, and all the compliance has been complied, Lordship.
Lordship, compliances were not made. That's why this petition is still pending. As per order dated 28 February 2000 this year, Lordship, petitioner has been instructed to get a necessary information and verification, because it is not a case where the funds is it's not a case of insufficient fund received from the central government. The entitlement is that as per the National Food Security Act and the rules, Lordship, the entitlement has to be given for 300 days. And this has been the affidavit submitted by the state says that for 25 days in a month, food as hot cooked meal has been given, but that is not the case. Lordship, now the petition concerns the poor people, especially the lactating mother during the time of from the time of delivery till 6 months, and also during the time of pregnancy. Here, the poor people need supplementary nutrition, and also children from 6 months to 6 years, including malnourished children. We are concerned about poor people living in the villages who does not have access to.
When your affidavit was filed? I didn't.
Lordship, in my additional affidavit, is filed in the month of October, Lordships.
Deficiency difference. What is the deficiency difference? October.
Lordship.
Madam, have you responded to this or have you obtained instruction? about
Lordship.
the Allegation made in this. Say, for example, they have given some charts.
Lordship, I have not filed my affidavit. I have just received the instruction in a letter format.
In response to this,
Uh,
18 October,
no, Lordship, I have not filed.
because on the previous date,
So if the court permits, lordship, we may file the affidavit, but
It has been observed that additional affidavit filed on behalf of the petitioner has not been responded by the respondent three.
lordship, sequently, if I may take lordships,
And on the previous day, you were absent actually.
lordship,
Somebody
I
else
was,
appeared
lordship, the last
uh,
Friday, lordship, I was not
to
there.
respond to this affidavit.
Lordship.
Otherwise, see this, for the whole year, only 3 cartons of biscuit.
Lordship. Since it is a fact finding, the fact finding team has
Lordship,
that one,
these are,
lordship,
these are the
required-
report of the Gauhati Center, Lordship. We just place it before the court as one example, Lordships.
How do you ensure that beneficiaries would be getting?
Lordship, that's why lordship,
as per the
earlier,
scheme?
lordship, whatever is
So what is your
submitted,
instruction? Let us see.
whatever,
Aadhaar registration.
lordship, that is taking place, lord, that's an ongoing lordship. The verification is ongoing, lordship.
As per any directive of the.
Lordship,
Union
as per
government.
the direction of the ministry only, lordship.
Let us see.
We just received the email, lordship, so it's not very clear, lordship, my apology, lordship. However, lordship, in earlier one of the PIL also, lordship, in 2021 to 2024 also, this same scheme was challenged under the ICTS and it was disposed of by order dated 21 to 2024, lordship. So similarly, my humble prayers that lordship,
How much advancement you have made as regards this Poshan tracker
Tracker,
application?
lordship. That lordship, that data is not with me, lordship, my apology.
Please the data then.
Lordship.
You place the data.
Lordship.
Things are going on
Lordship.
in proper
Otherwise,
direction.
in lordship, compliance is going on, lordship. And just for our discussion's sake also, lordship, that whatever is uploaded, only the food items are receiving, lordship. Unlike other toasties, lordship.
See, the beneficiaries are deserving.
Madam, in the order of 28 to 2024,
Lordship,
the union have categorically stated that we are giving funds to the state of Nagaland.
lordship,
We asked you as to how are you using it? Are
Sure.
you utilizing it properly so that you are giving it? That is why we asked you to get instructions on 28 to 2024.
lordship. That I have filed my affidavit, lordship, the utilization compliance that I have filed it, lordship.
Which date?
That is by
2nd of April 2024.
lordship,
I think 2nd of April.
the entire utilization certificate was filed on
2nd of April.
26 March, lordship, 2024. 26 March 2024.
26 March.
Lordship, that the bulky lordship.
It's 2nd of April.
This bulky one.
Lordship,
It is
Lordship.
filed by whom?
this was filed by respondent number 3, lordship.
That is what,
State.
one Mr. A. Tosili Jimomi,
Lordship.
2nd of April 2020.
Lordship.
The Yangamati, you have received the utilization certificate from the state. Because these are the utilization certificates which have been enclosed. But
Yes, sir.
what is your stand of your government that have they accepted this utilization certificate? Because they do it after certain verifications being carried out.
Yeah, yeah. Yeah, just Bismillah. Then look at the sanction order, according to sanction order, you see that.
Are you getting fresh grants every time?
Lordship,
Every
Lordship.
year? Now
Lordship.
also you are getting,
Yes, Lordship.
because you can get only after you submit your utilization.
You see, Lordship. Correct, Lordship.
Madam, you make a
Lordship.
reply to the affidavit
Lordship.
of the petition affidavit of petitioner and
Lordship.
plus place an up-to-date data status
Lordship, Lordship.
as regards this portion tracker application, because I think it is all pervasive.
Lordship,
It
Lordship.
shows that data will be entered
Yes,
in the
Lordship.
tracker application.
Yes, Lordship.
How much monthly wise supplementary nutrition has been given, take home ration given to pregnant women, lactating mother, children 6 months to 3 years, both active, inactive. You
Lordship,
get the
Lordship.
up-to-date status so
Lordship.
that they will have
What-
their also information in their mobiles.
Lordship. Earlier in one of my compliance dated 4/5/2022, we have uploaded and there were about 3,50,660. That is 6 months to 6 years, and 40,115 pregnant and lactating mothers beneficiaries were there. So that was filed in 2022. But now it will, in fact, it will come down, Lordship. Because of the uploading, it may come down definitely. It will decrease beneficiaries.
Yes, madam. Now they will be tracking everything.
Yes, Lordship.
And
I
time
hope it is transparently implemented.
Lordship. In fact, Lordship, the blocks, there are 60 blocks, ICTS blocks, and there are about 3,980 Anganwadi centers in the entire state, Lordship. Now, the direction being given by the state is also that now the children, especially 6 months to 6 years, they have to upload their Aadhaar through their parents. So the parents' Aadhaar has to be also upgraded once it is 10 years, more than 10 years. So that aside, the arrangement is going on, but still people are also not coming forward. And in far off the places, the things are becoming worse in Lordship. As far as the Pushan tracker is concerned, Lordship.
MS
But-
only Buchan. Your name?
Apila Sanctum, Lordship.
Adam, why don't you also enlighten your people out there and that they should get hold of this Aadhaar and all? so
Lordship,
that
Lordship.
If you make them aware about these things, what are required, then they would be able to take the benefit.
Exactly.
Lordship. In fact, in the villages, the poor people, if they're getting entitlement, they're very cooperative, Lordship. Angawadi workers have been stationed in the village itself. So I don't see any reason why they should refuse to upload their Aadhaar card. But as you have rightfully suggested, I would also pass on the information.
Learned
Lordship.
Counsel for the response number 3 has submitted that as per the directives of the Union of India, the state of Nagaland is in the process of implementing the portion tracker application,
Lordship.
which is to be linked with Aadhaar.
Lordship, Lordship.
As per the portion tracker application, is stock register module for Anganwadi workers, allowing monthly tracking of SNP stock with detailed records, date-wise entry for received stock, and updated distribution based on daily THR/CM. I don't know. Enhancing efficiency in stock management and beneficiary tracking at Anganwadi centers is envisaged. First up, there will be there is a portion tracker dashboard introduced on supplementary nutrition, which represents one month-wise count of supplementary nutrition. Two, take-home ration given to pregnant women, lactating mother and children of 6 months to 3 years, within bracket, both active plus inactive beneficiaries, and hot cooked meal given to 3 years to 6 years children, within bracket, both active plus inactive beneficiaries, bracket close, includes only non-school going children. Full stop. The data, the project by the portion tracker dashboard, beneficiary data is contemplated to be made available at project sector Anganwadi center level. The portion tracker dashboard will assist on SNP projections that would represent count of other verified active beneficiaries as on the last day of each month. As MS so and so Apila,
Lordship.
Sanctum, Council for the Respondent.
3 Lordships.
Has submitted that the state of Nagaland, the process of implementing the portion tracker application is in progress. We granted how much time?
3 months, Lordship.
Huh?
3 months. Since
Not
it's an
3 months.
ongoing Lordship.
Vacation. 1 month.
Lordship,
1st of February.
1st of February, Lordship.
We granted time till 1st of February.
Lordship, to file the status report, Lordship.
Status report on the implementation, in respect of implementation of portion tracker app. First of, the respondent number 3 shall also respond to the additional affidavit filed by the petitioner on 18/3/2024.
Lordship, Lordship.
1810.
1910.
Before that, MS Native Koja. MS Native Koja and Council for the petition is present. Heard. Mr. Yangarbati, Landed Central Government Council, shall obtain instruction as regards the acceptance or otherwise of the utilization certificates submitted by on behalf of the state of Nagaland regarding in the affidavit filed before this court on 2/4/2020. See, is there any audit objections? It has been accepted by the Auditor General of India or not?
For a year 2020, because the petition was filed in 2020. So
No, they have given the utilization certificate. Get to know. By this time, I think auditor report is ready by the Auditor General.
Lordship. Lordship.
As is there any standing counsel for State Legal Service Authority, Nagaland State Legal Service Authority?
I'm the standing counsel, Lordship.
You are.
Lordship.
So you can also, apart from Director of Medical Health,
Lordship.
Oh, Lordship, I think there are other impaneled panel lawyers also.
the member secretary will be in the best position
Lordship.
to supervise or to get information and to spread awareness about this portion tracker application.
Lordship, Lordship. In the recent last week also, the awareness was done, Lordship. In fact, we've gone up to Noklak and Shamtor, Lordship, the new districts. The last week, Lordship. The awareness has been made, Lordship, and stakeholders were called.
And the council for the response number 3, who is also the standing council of a Nagaland State Legal Services Authority, shall apprise this court about the awareness program undertaken by the State Legal Services Authority and the District Legal Services Authority
Lordship.
amongst the beneficiaries as regards the portion tracker app.
Lordship, Lordship.
So you'll organize camp,
Copy of this order may be finished lost.
a copy of this order. As requested, a copy of this order be supplied to Mr. Yangarbati, Landed Central Government Council, for taking necessary steps from his end.
Obliged, Lordships.
For admission, item number 3.
May I please your Lordships?
Yes.
Lordships, here the petitioner is seeking for revocation of the detention order dated 22nd February 2024 passed by the detaining authority, detaining him under the National Security Act, Lordship. Lordship, the brief fact is that the present petitioner was arrested in connection with the TCPS Mon on 17th of February 2024 under section 384 IPC read with 7 in a SAR. Seven is inserted and read with section 10 UAP Act, Lordship. Any Lordship.
Come to page 23.
Lordship.
It was enabled. How can the detainee
Lordship.
show it is affidavit?
Lordship, we went to Dimapur ourselves, Lordship, and we took the signature from the Dimapur itself.
Also notary.
Lordship, notary is one of my seniors junior, Lordship, but he's not in this case, Lordship. Lordship.
And we can contact he has a mobile phone inside the jail.
No, Lordship, this is the relative of the Lordship. Since it's a mandatory, so we had to, Lordship. It's the relative of the detainee, Lordship.
Madam, you file an affidavit through his next friend. Maybe wife, maybe brother. Fifteenth day of October at Dimapur.
Lordship, that is the day we served the representation also, Lordship.
What has happened to your representation?
Lordship, as of now, no, till date, no update, Lordship. However, in meantime, after filing this writ, they have also extended the extension again, Lordship.
What are the grounds?
Lordship, my first ground is that the
Grounds of detention.
Lordship, the detention order is at Annexure C, page 36, Lordship. The grounds is at page 37. May I read, Lordship?
Madam, file an affidavit to the next friend. Because we have been consistently holding it, that next friend should file the affidavit to support the writ petition.
Lordship,
On last 3 dates, we are doing that.
His wife. Here's the wife.
no, Lordship, here the petitioner itself is the detainee himself.
Right.
You has a wife.
Lordship, I believe so.
Or
Yes.
brother,
Ask him to say what he is saying in the petition by way of an additional affidavit.
Lordship, in that case, if since 13th is the last date of this yeah, Lordship, so vacation decision. 20. Lordship, if Petition bench.
Oh. Madam, it will not be proper for us to take cognizance of it when other petitions we have asked to file a affidavit to the next friend. That is a difficulty now.
Lordship.
What is the date of the detention order?
22nd February, Lordship, 2024, Lordship.
How is it going beyond that? Madam? If it is the detention order is of 29th of February, 2023.
2024, Lordship. It's 2024, Lordship. They have given a corrigendum also,
Oh.
Lordship. Yes, Lordship.
Oh, 7th of March.
Yes. But
File it. But
Lodge.
problem is that tomorrow or day after tomorrow may not be revision match. Because we are holding it just for taking up this NSA, otherwise that division bench matters are to be listed on Wednesday. And we're sitting on Monday, Tuesday, Wednesday, every day, take up this NSA matter, but we are finding it defective to take up.
Lordship, in that case of Friday, if Lordship, he's been under custody for almost 8 months, Lordship. So
So if it is not further extended, he'll be out.
extension is out, Lordship. They have extended till 2nd of February next year, Lordship, 2025.
2nd of February.
22nd of February, 2025, Lordship.
What to do? Can at best, because any division bench during vacation.
No, Lordship, I'm informed that it's a single bench, Lordship.
Okay, file tomorrow morning.
Lordship,
File that affidavit.
Lordship,
Had
much obliged, Lordship.
MS
Mikai Chair, Your Lordship.
Mika,
Lordship.
Yachula, learned counsel for the petitioner, and MS Libika, learned state counsel, and Mr. J. Anguli, learned central government counsel for the respondents. Full stop. MS so-and-so, learned counsel for the petitioner, has sought leave to file an additional affidavit in this petition through the next train of the Detention by tomorrow in order to cure the defects. First of the leave sought for, comma is allowed to file the affidavit by tomorrow. Please, that is tomorrow.
Much obliged,
If you
Lordship.
file it, otherwise, then it will otherwise go to 16th of January.
Yes, Lordship. Much obliged, Lordship.
For admission, item number 5.
Yeah, His Lordship. My sincere apology, Lordship. In the last order, I was directed to file an affidavit with regard to why it's not possible to install blood bank in all the district hospitals, Lordship.
Blood bank.
1311, Lordship, 1311, last order. I was granted 4 weeks time to file an affidavit, my Lord. I could not file an affidavit in time, Lordship. My sincere apology, Lordship. As far as compliance of the order dated 6/11/2024, we have already set up 4 blood banks in the district of Tingsang, Kifri, Mon, and Pek. We have already filed an affidavit, Lordship. Besides the existing blood banks in the district of Wokha, Mokchung, Kohima, and Dimapur, we have set up 4 additional blood banks, Lordship. Now, we have made a submission before the court, Lordship. Why we could not have blood bank in all the districts, Lordship? Because there are certain criteria that we have to fulfill with regard to consumption. There should be at least 2,000 liter in a year to get a blood bank license, Lordship. So I was directed to file an affidavit to that effect, Lordship. But my sincere apology, I totally overlooked, Lordship, today. So if this matter can come up after vacation, Lordship, I'll be filing the affidavit in compliance of the last order, Lordship.
No objection.
MS Native Koja, learned counsel for the PL petitioner, and Mojui, learned standing counsel for the National Health Mission
Lordship.
and Health and Family Welfare Department for the respondent number 1, 2, and 3, 1, 2, 3, and 4, and
Lordship.
Mr. Younger, but learned central government counsel for the respondent number 5 and 6 are present. Had first of Mr. Mojui has submitted that the affidavit in deference to the order dated 13/11/2024
Lordship.
could not be filed due to non-receipt of complete instructions. He has thus prayed for listing of the case
After vacations.
after vacation. On 22,
Lord.
29 January 2024,
Lordship.
in order to enable him to file the affidavit in deference to the order dated so and so. As the prayer is not objected to by the learned counsel for the petitioner, raise the case for filing of the compliance affidavit.
Deeply obliged, Your Lordships.
Or Mr. Angami, I think that NSA matter.
Yes.
You keep the records. You were there, or Libika, MS Libika. Tell her to keep the records. NSA matter. Just called sometime earlier. MS Libika was there. Keep-
In item number 2 also, huh? Item number 2, who mentioned? Mr. Angami, you mentioned item number 2.
Mentioned.
No, not me, Lordship.
Oh, Mr. Jibomi mentioned.
I think so, Lordship.
So ask him also to get the records.
Oh, Lordship.
Because we are fixing tomorrow. Otherwise, without the records, it will become.
Lordship.
For admission from the supplementary course list, item number 16.
May it please your lordship. I am doing it by VC today. The matter, your lordship, yesterday your lordship has inquired whether the extension was given or not. It was given, your lordship. I have got the copy of that order, your lordship. So, your lordship, now he is in custody. Therefore, your lordship, I would like to continue with my grounds on which I base the whole case, your lordship.
No, Mr. This is not your case. This is item number 17. 16. You are giving motion item.
Oh.
16. Admission. Supplementary.
Yes, your lordship. I'll just take your lordship first to page 18, your lordship, 1/8 of the petition, your lordship, writ petition, page 1/8. This is the proposal, your lordship. I'm bringing to this because here the facts have been given. I'll just give the facts and then come into the grounds directly, your lordship. I have taken 4 or 5 grounds on which I'm basing the challenging the basically this preventive detention under the PIT NDPS Act. Page 18 for a moment. I'll just read this. This is actually from this the whole case is made out. Please find herewith a proposal for detention under section 3(1) of the PIT NDPS Act 1988 along with the relied upon documents. I'm giving that position relied upon documents. This is important. For detention of the accused Kumar Chetri, so and so, Assam, Karbi Anglong. He was arrested in connection with SBN PS case number so and so under section 21B of the NDPS Act. So, your lordship, 21B is not a commercial quantity. It is below commercial quantity. So, I'm just pointing out this and read with section 34 of the IPC, your lordship. Next paragraph is the facts. On 21/4/2024 at around 11 hours, information received from the reliable source about the movement of dark peddlers at Rail Bazaar area. Accordingly, it was intimated to the superior officers, and a team of police headed by ACP West so and so conducted the operation at Rail Bazaar area. And after a long pursuit, 2 persons were intercepted: Srimati so and so, son of so and so Assam, and Kumar Chetri. And on conducting search, so and so soap cases suspected of heroin weighing so and so grams were recovered from the possession of Srimati so and so. So and so. And on inquiry, she stated that those seized items belong to Kumar Chetri. So and so. The arrested person along with the seized items were produced by Suburban Police Station according to the receipt of the written FIR. So and so, section 21B NDPS and read with section 34 was registered. Now, your lordship, I'll read the next paragraph. I'll not read it because it's the I think the date of birth and other things of this person. Then, your lordship, the next paragraph, it shows from these 2 paragraphs, basically, the rest are the facts have been further elaborated. Basically, here what has happened, the amount was recovered from the possession of Srimati Babi Sahu, not from the petitioner, number 1. Number 2, your lordship, it was on the inquiry, she stated that it has been, it was of Kumar Chetri. So, the co-accused had named the petitioner. These are the grounds on which the petitioner was arrested. And the second point is that it is the narcotics is not of commercial quantity because the case is registered under section 21B of NDPS Act. So here, your lordship, it comes. Now, your lordship, what I'm trying to point out, this is the only ground, only case against the petitioner. It's the solitary case against the petitioner. The petitioner, there is no antecedent of any other case in the order of detention. This is the only case on which he has been arrested. So therefore, this cannot be said to be a habitual offender also. So these are the points on the factual part of this case, Your Lordship. Next page, Your Lordship, page 20. They have given the grounds of detention. I'll read this, Your Lordship. The accused admitted to illegal trafficking of narcotic drugs, narcotics, marketing the same substance in the and around Dimapur town, conforming to nets under section so and so PIT and DPS. The state of Nagaland lies within the area of vulnerable to illicit traffic in narcotic drugs and psychotropic substances, as mentioned under section 10(5)(c) of PIT and DPS. And it is pertinent to mention here that the accused admitted the seized contraband recovered was received from 6 Mile, so and so, and earlier consignment sold in Assam indicates that the accused has an inter-district, interstate linkage spreading across states of Nagaland, Assam. A2, that A2 at large, if bail, will be a threat to peace and security of the state of Nagaland, and there is a likelihood of the accused committing breach of peace and tranquility in the state, thereby endangering lives of many innocent, peaceful existence of citizens and may warrant law and order problems in the state. There has been a public outcry concerning transit traffic of drugs in the state, which is causing problems of abuse of addiction of all age groups. Yes. No. Lordship?
Yes.
So from here, the only thing is that he was arrested with regard to only one case, and that case also it was a less than commercial quantity. No antecedent has been reflected. No cases, in fact, no other cases has been reflected in the order of detention. And his from that it can be derived is not a habitual. Now, Your Lordship will kindly one point will come up whether this petitioner was given the given a representation against the order or not. In this case, I have a ground to state that he could not file his representation on two specific ground. I'll rely on this. Number one is that he was arrested in Nagaland and he is from Assam. So there was no specific coordination with anybody from outside so that he could file a specifically representation from the jail custody. Secondly, Your Lordship, the dossier or basically the documents which I stated, that documents on which it was relied upon to arrest the person and which has been relied upon for the Your Lordship preventive detention have not all been provided. Yes, the order of detention, the other Your Lordship proposals have been provided to him because they have taken a signature of that. Though in my writ petition I have said that it was not provided, but these two petitions have been provided. But apart from that, the documents with regard to the statement of the co-accused, because he was arrested on the basis of the statement of the co-accused, nothing was recovered from him. It was recovered from the other person, and various other documents on which they relied for this preventive detention have not been provided to him. So this is the ground on which I allege. Number three, Your Lordship, my number three is that now.
Mandan, are you referring to the recent judgment of Justice Gauhati?
The Gauhati judgment I'm not referring, because I have in fact in my additional affidavit, I have given the citations of the judgments so that it will be easier for the other side while the matter is posted before this honorable bench. So I have given those judgments. I am relying on those judgments in this case with regard to the points which I am raising, Your Lordship.
In acknowledgement certificate.
Yes, they have given an acknowledgement certificate. They have provided me with the copy of the yes.
It's enclosures.
Yes, and the enclosures are provided where they have enclosed the order, the proposal also, which I have also annexed, Your Lordship. The proposal, the order, the grounds of detention, all these have been given. But the documents on Lordship.
Right upon documents.
The documents means which documents I am just referring to are the documents with regard to the statement of the co-accused, the documents on which they rely upon in arresting me in the case, NDPS case. These documents are not provided, Your Lordship. These are not provided. These are not provided.
Any stand on that?
Yes, I have taken that, Your Lordship. I have taken that in my additional affidavit also. I have stated that, and I have also given the judgments on which I am relying, Your Lordship.
No, where have you stated?
Lordship will see at para 5 of the additional affidavit, Your Lordship. Sorry, reply, affidavit in reply that I have filed. Para 5.
Sir, Manan, we can see the proposal again, which you are referring to.
Yes, yes.
Proposal for detention. Then the enclosed down below.
Yes.
B2K.
Police report and all supporting documents of this case.
Page 30.
Yes. Yes, I have seen that, Your Lordship. That documents are the documents with regard to the police report, which I have already annexed. Police report, the proposal, the order,
No.
and the grounds.
Mr. Manan,
Yes.
kindly come to page 30 of your petition.
Yes.
Enclosed
Yes.
documents in annexure A to K.
Lordship.
And these are the relied upon documents.
Yes.
Have you got any of them?
Those documents, Your Lordship, as per my instructions, all the documents were not provided. Even if those,
What are the
because
documents provided?
the provided documents are the proposal, the document which is basically the grounds, and the document of order. First is the order, then the grounds of detention, proposal, and the police report. But one document, that is what I am trying to point out, was the document with regard to the
What I have seen, proposal to A2. Proposal to A2. This is what detention order to pass for it. Detention. A reliable document means what mentioned position. Order of detention which is for grounds of detention to A2. A2. A. Enclosure. Supporting documents per case.
Lordship, I'll just Lo- Lordship, the documents that have been provided, I'm just saying A to K. I'll just say because I have got number 1 is the FIR copy, annexure A. B is the complaint. C is the seizure memo. D is the arrest memo. And then, Your Lordship, medical report of the accused. FSL examination, letter sent for FSL examination that has been given. The judicial remand order. Then, Your Lordship, the inventory list and my statement. before them, your lordship, and the photograph of my photograph,
So these
accused photograph.
form the basis of the opinion, detention order.
Mainly what happens, your lordship, I was detained, nothing was recovered from me. I was detained on the basis of the statement of the other accused.
No, Mr. Mannan, your earlier
Yes.
suggestion was that the relied upon documents were not provided to you.
Yes, so these particular document I am just mentioning, these documents apart from the,
That made us to go through the files.
no, so that is why I also got the file, your lord.
We have found that all the documents have been provided.
Anyways, your lordship, the main,
These are procedural compliance because you have
yes,
nothing was provided, relied upon
no,
documents.
not nothing. I said some documents are provided apart from the police report contains this, your lordship, documents. And apart from that, yes,
Is there the document from annexure A to K?
A to K, yes.
So all the documents.
These documents are provided. I cannot deny that, your lordship. I cannot deny that, but I'm just saying that the statement of the accused witnesses have not been provided. That is what I'm trying to point out from the very beginning. So apart from this, that was also one of the grounds. On that,
Statement under section 161
161 is not provided.
is not to be provided till the stage 207 is reached.
Exactly. 164 have also not been provided with regard to the co-accused, your lordship. Anyway, that is one point. Now, your lordship, the second part that I'm relying on is that there's only now, your lordship will I'll be submitting a few judgments. My junior counsel there will be providing the judgments on this regard that I have already stated in the affidavit. She will be providing a copy of that. First, your lordship will kindly take up the judgment of Human Yongbi Limbi Lema, that is 2012 2 SCC 176, your lordship.
That's the Manipur judgment.
This is a Manipur judgment, your lordship. Here, I'm just trying to point out one point that I have already raised, is that this is the only case which the petitioner has been arrested, only one case. Here, your lordship, I'll take your lordship to the paragraph 23, your lordship. Having carefully considered the submissions made on behalf of the respective parties, we are inclined to hold that the exercise of extraordinary
Mr. Manan, which judgment?
judgment of Human Ongbi Lemmi Lemba. This is 2012.
Rekha judgment.
No, 2012 to SCC 176.
I mean, give me the Rekha judgment.
No, my junior colleague is there. She should provide that. I have asked her to provide all the judgments.
So what is the point you are conversing there?
Here, my point I am canvassing is on two grounds. Number one is that when there is an individual incident, it says an individual incident of an offense under the code, however heinous, is insufficient to make out a case for issuance of an order of preventive detention. So here is a single case, that too, your lordship, not a commercial quantity, on the basis of which the whole my preventive detention was done. So just one case does not make it a case for preventive detention. That is what in this case at para 27 it has been stated. I have, in fact, the judgment I have already asked her to provide all these judgments, all the 6 judgments that I am relying on, 6 or 7 euros. So that is in paragraph 25 of this judgment. I am also referring to Rekha, but first I'm bringing this because this is only one incident, and in the detention order as well as the proposal as well as the grounds, they did not cite any other case apart from this only case, your lordship. This is why I am bringing this judgment for your lordship's knowledge. 2012 2 SCC 176. Lordship will kindly turn to para 27. As has been observed in various cases of similar nature by the court, The personal liberty of an individual is most precious and prized right guaranteed under the Constitution in Part 3 thereof. The state has been granted the power to curb such rights under criminal laws, as also under the laws of preventive detention, which therefore we are required to be exercised with due caution as well as upon a proper appreciation of facts as to whether such acts are in any way prejudicial to the interest and the security of the state and its citizens, or seek to disturb public law and order, warranting the issue of such an order. An individual incident of an offense under the penal code, however heinous, is insufficient to make out a case for issuance of an order of preventive detention. So this part I'm bringing it on the point that he's not an habitual offender. Only on one case the order was issued. Now the second case that I'm relying is Rekha.
That is a case on a penal.
Maybe. But what court says that in a case, in one instance, normally a preventive detention order should not be issued. This is not an NDPS case. In that case, fine. But even then, it has been stated that in one case, just in one case, you cannot do that. That was a case of 302. Eh,
1 minute.
yes.
Are you referring to another judgment in Gita? No, na?
No, I was referring to this, the same judgment, para 23 and 27. 23 is with regard to the point that they have not disclosed any reason why I am supposed to be granted bail. Because the order of detention, they have stated that since I'll be granted bail, therefore I am allowed to be under detention. This point has been raised in para 23 of the same order, the same judgment I am referring to. It says that that cannot be a ground. So para 23, if your lordship allows, I may read that.
We have read it.
Yes, so it says that just that being the ground that he may be released on bail will not.
Yes, Mr.
Yes, Your Lordship. The first case that I have referred to was with regard to these 2 points, para 23 and 27.
Lima, 2012.
Lema. Yes. Lema para 23 and 27. Going further on that, Your Lordship, I'd like to now refer to the case of Rekha. Rekha versus State of Tamil Nadu, 2011, 5 SCC 244. Your Lordship. In
Yes.
this case, Your Lordship will kindly straightaway turn to paragraph 11, 1. In our opinion, Your Lordship, para 11, in our opinion. In our opinion, the detention order in question only contains ipse regarding the alleged imminent possibility of the accused coming out on bail, and there is no reliable material to this effect. Hence, the detention order in question cannot be sustained. This is a very short part. Now, Your Lordship, it has been elaborated in para 12. Moreover, even if bail application of the petitioner relating to the same case is pending in a criminal case, the detention order can still be challenged on various grounds. That is, the act in question related to law and order and public order, and that there was no relevant materials on which the detention order was passed, that there were malefides, that the order was not passed by competent authority, that the condition precedent for exercise of power did not exist, and that subjective satisfaction was irrational, that there was non-application of mind, that the grounds are vague, indefinite, irrelevant, extraneous, non-existence or stale, and there was delay in passing the detention order or delay in executing or delay in deciding the representation of the detainee, that the order that was approved by the government, that there was failure to refer to a case to the advisory board or the reference was belated. Para 13. In our opinion, Article 22(3)(b) of the Constitution of India, which permits preventive detention, is only an exception to Article 21 of the Constitution. An exception is an exception and cannot ordinarily nullify the full force of the main rule, which is the right to liberty under Article 21 of the Constitution. Fundamental rights are meant for protecting the civil liberties of people and do not put them in jail for a long period without recourse to a lawyer or without a trial. The imposition of what is in effect a substantial term of imprisonment by the exercise of executive discretion without trial lies uneasy and ordinary concept of the rule of law. Article 22 hence cannot be read in isolation but must be read as an exception to Article 21. An exception can apply only in rare and exceptional cases, and it cannot override the main rule. In this case is not a rare and exceptional case, Your Lordship. Para 14, Your Lordship. Article 21 is the most important of the fundamental rights guaranteed by the Constitution of India. Liberty of a citizen is the most important right won by our forefathers after long historical and arduous struggle. Our founding fathers realized its value because they had seen during the freedom struggle civil liberties of our countrymen being trampled upon by foreigners, and that is why they have determined that the right to individual liberty would be placed at the highest pedestal, along with the right to life as the basis of the people of India, Your Lordship. Then Your Lordship will kindly take up paragraph 29, 29. Preventive detention is by nature repugnant to democratic ideas and anathema to the rule of law. No such law exists in USA and in England except in one time. Since, however, Article 22(3)(b) of the Constitution of India permits preventive detention, we cannot hold it illegal, but we must confine the powers of preventive detention within very narrow limits. Otherwise, we will be taking away the great right to liberty guaranteed by Article 21 of the Constitution of India, which is won after long, arduous, and historical struggle. It follows, therefore, that if the ordinary law of the land, the penal code, and other penal statutes can deal with a situation, recourse to preventive law will be illegal. Now, here, Your Lordship, what has happened? I am already under the NDPS Act. And NDPS Act can specifically take care of my, if I am at all, Your Lordship, done the act under the NDPS Act, then in the course of law, it will be taken care of. Why I should be put under preventive detention? This is the question, Your Lordship. Now, next paragraph, Your Lordship will kindly read. Very, yes.
Tamanna,
Yes.
you don't come within the purview of section 37.
No, because it is less than commercial quantity.
So,
Exactly.
there will be, there's no,
So,
you can be
that they have not stated, Your Lordship. They have not disclosed. I have not been granted bail till today, Your Lordship, in this case. That is one reason I have come. Then they have come up with a preventive detention. I filed this against the preventive detention. And there they said that you might be given, you might be granted bail. Now the question is, second part also, Your Lordship. If I am entitled to be tried under the NDPS Act, why I have put under the, Your Lordship, this preventive detention, Your Lordship? Is there no case against me under the NDPS Act? If there's no case, they should not have put me under preventive detention. These are actually contradicting each other.
They have not put it in so many words, but the fact that you don't come within the purview of 37, so they
37 will not come because it's less than commercial quantity. That is true.
moment we
That-
say we revoke or set aside the order of detention, then obviously the next morning you get the bail.
Like that is up to the court. That is why I'm saying, Your Lordship, one thing, there is another judgment, Bankas Neha Sila, what I will come to that. There's one paragraph, just one paragraph I'll refer in that case. That is a recent case of 2021, where it says, if at all there is something against me, you can, Your Lordship, challenge the bail and other conditions. That I'll come. But just read the next paragraph in this case, Your Lordship. Paragraph 29, 30. That part, Your Lordship, I would also add, just because I may be granted bail, can I be put into preventive detention? That cannot be a ground. Your Lordship. That cannot be a ground. Then, because 37 does not come, whatever it is, they have to, that will take its own course. But here in preventive detention, they cannot bring in that, Your Lordship. In para 30, Your Lordship, kindly read the same judgment. Paragraph 30, where court has been.
Amina Begum's judgment.
Which one?
Amina Begum.
Amina Begum judgment. Actually, what has happened, Your Lordship, when I filed this, there are 6 judgments were referred here. So I am only referring on those. I am not bringing any new judgments.
You don't refer to judgments in your readings.
No, what has happened, Your Lordship, because I am doing it from here, VC, and the other council will be alleging that these judgments were not provided. That is why it was put in the pleadings.
So
That is the only reason. Otherwise, in cases where I appear, Lordship will never find any judgments annexed. But here it was for the convenience of the respondents we have done it. Your Lordship.
your inter-council and help you have burdened these pleadings with those judgments. Anyway, you see, Amina Begum is a important judgment of the Supreme Court, wherein it says
Lordship.
the powers when the powers of a writ of habeas corpus should be exercised.
Yes, Mr.
Yes, Your Lordship, the just one paragraph that I was referring from the same judgment of Rekha, Your Lordship.
Raka, yes.
Yes. Para 30, Your Lordship. The next paragraph, the 29 I have read, 30, para 30, Your Lordship. Whenever an order under a preventive detention law is challenged, one of the questions the court must ask in deciding its legality is, was the ordinary law of the land sufficient to deal with the situation? If the answer is in affirmative, the detention order will be illegal. So that is my simple case, Your Lordship. In this case, NDPS Act is there. Why is this necessary for putting me under preventive detention? Is the in the present case, the charge against the detainee was of selling expired drugs after changing the levels. Surely the relevant provisions of the Penal Code and the Drugs and Cosmetic Acts are sufficient to deal with the situation. Hence, in our opinion, for this reason also, the detention order in question is illegal. Here, in this case, he was arrested on the grounds of alleged drugs, Your Lordship. So,
Hey, give us it.
Yes, what is the next judgment?
The next, your lordship, is 2021 9 SCC 415 Bankas Neha Shila versus State of Telangana.
Yes.
Here, your lordship, is a very long judgment. Here, in fact, in this judgment, the judgment of Rekha, human, Ongbi, everything has been discussed. I'll not read because it is the same thing has been referred again and again. In para 24, 25, Rekha has been referred. And then in para 29, woman Ongbi Limba has been said. Now your lordship will come to para 30, 30. Another case has been referred, which I am not referring here, so I am reading that. Para 30, I'll read only two paragraphs, 30 and 32. This judgment was followed in Mungala Yadama Swenso as follows. This is judgment quoted of 2012, Your Lordship. Having considered the submissions made on behalf of the respective parties, we are unable to accept the submissions made on behalf of the state in view of the fact that the decision in Rekha case, in our view, clearly covers the fact of the case as well. The offences complained of against the appellant are of the nature which can be dealt under the ordinary law of the land. Taking recourse to the provisions of preventive detention is contrary to the constitutional guarantees enshrined in Articles 19 and 21 of the Constitution, and sufficient grounds have to be made out by the detaining authority to invoke such provisions. Then the Yumban Longbi lemma has been quoted. I'll not read that. Now I'll directly read paragraph 32. What the court says, Your Lord. On the facts of the case, as has been pointed out by us, it is clear that at the highest, a possible apprehension of breach and law and order can be said to be made out if it is apprehended that the detainee, if set free, will continue to cheat gullible persons. This may be a good ground for appeal against the bail orders granted or to cancel bail, but certainly cannot provide a springboard to move under a preventive detention statute. That is what I am trying to say. Just because I may be granted bail in the case because Lordship says 37 will not apply, may not be also granted on the facts on the case or the circumstances on the record, whatever is there. But if it has done so, they have the option of doing that. But they cannot be, this cannot be a springboard to put me on jail under preventive detention.
Anything on subjective satisfaction?
These are the only judgments that I am referring, Your Lordship. And other three judgments that are there, they have already given another three judgments. These are only basis of with regard to furnishing of documents. What are the documents that required to be furnished? That is why I mentioned specifically the statement of the accused. That is why these three judgments were given. Your Lordship, these three judgments are, number one is 2021 4G. These two are from our Honorable Court. One is a Supreme Court judgment.
That does not arise, taking into account the
Yes.
records. So
Then I will not further, Your Lordship, make on that. So basically on this ground, Your Lordship, my humble submission will be that this person, Your Lordship, was actually trying to put into the kept in custody on the basis that he might be granted bail in the other case. This is the only ground, Your Lordship, sole ground. They do not have a case against me because the whole issue was with regard to the fact that the quantity is less than commercial quantity. And normally section 37, it will not be applicable. In that case, I might get bail. But that cannot be a ground to keep me in preventive detention. This is basically my case, Your Lordship.
Mr. Manan, should we record your submission to the justice?
No. I cannot say that specifically. I'm putting it, Your Lordships, from Your Lordship's mouth. I got that. That is why I'm putting it that way. Lordship's mouth, it has come out, and I'm just putting it back. And one more thing, Your Lordship, just refer to Amina Begum. Can I, Lordship, can just point out whether the citation of the matter, Your Lordship, if it is there?
You want it?
Yeah, just let me, for my own benefit, Your Lordship. If it is there with Your Lordship, then.
Amina Begum is, not with me. Let us help the council from the principal seat of 2023 9 SCC 587.
Yes, Your Lordship.
And Mr. Manan, kindly look into the judgment, which is actually the most relevant judgment for you is 12 7 SCC 18.
2012.
7 SCC
181.
1. 7 SCC.
Okay.
Lordships, as regard representation and supplying of dossiers, my lords have taken note of it. Necessary things has been done. Then coming to the likelihood of pending bail, as my lords have rightly observed, state is not prosecution is armed with the section 37 here. So likelihood of getting bail is very high, Lordship. Now, as per the finding here, he was the detainee is in the business of narcotics since 2022, Lordship. And the finding of 100, a little bit above 100 grams could be just a tip of the iceberg. And now the prevention is not a punishment, as my lord knows, better. So I think altogether, this is a perfectly fit case of issuing preventive detention, Lordship.
Why didn't you submitted the charge sheet?
Lordship.
Charge sheet. Yeah, held him for quite a long time.
Chargeship, as far as regarding the chargeship, I have no instruction, Lordship. So my prayer is, I pray that the detention order may not be interfered with.
Yes.
Yes, Lordship.
Right, Mr. Y.S. Wanam. Learned counsel for the petition through video conferencing mode from accepted by MS. Learned counsel for the petition and Mr. K.V. Angami, learned public prosecutor for the respondent state of Nagaland. First of arguments are heard. Judgment is reserved. Mr. Angami,
Yes,
this file, you take it back on Friday.
Yes, yes, Lordship. Yes,
It is possible to deliver Friday, okay?
Lordship,
Otherwise, it will
no
be
problem,
delivered from
Lordship.
principal seat.
Lordship,
But you take back the file
Lordship,
on Friday,
Lordship,
right?
yes, Lordship.
Much obliged, Your Lordship.
Yeah. Boardmaster. Huh? You did, yeah, you can tell. Huh? Yes, I did. Huh?
For orders. Item number 7.
May please, Lordship. Lordship, the stake by order dated judgment and order dated 10/6/2024, the learned single judge has directed the respondent number 3 and 4, that is the accountant general, to refix the pension of the petitioner as per the revised scale of pay. Whereas the direction was to the accountant general, it is the stake who has to pay the money. For that reason, Your Lordship, we are filing an appeal. And in filing the connected appeal, Your Lordship, there is a delay of 100 days. So, Your Lordship, I received the letter dated, that is at page 46, Your Lordship. Your Lordship, I received this letter dated 31 July 2024, requesting me to file an appeal against the judgment. which I received in the middle of
Page?
46. This is the letter, Your Lordship.
When is the judgment?
At the judgment, Your Lordship. The judgment is at page 7 of my condonation of delay petition, Your Lordship.
Yes, any objection to it?
And
Yes, my lord, I have filed my written objection.
Your Lordship, okay. The grounds I have given in at page 3, Your Lordship.
When it was filed ultimately?
Lordship, I filed it on 19 October 2024.
Why from 31st July?
Your Lordship, I have stated that I received in the middle of August. And after I received the letter, Your Lordship, since I was not the counsel in the earlier, Your Lordship, so I asked for the documents, which I received in the middle of the second week of September. Then only the preparation of the appeal started. Otherwise, Your Lordship, there is a grave perversity in the order, Your Lordship. And the Supreme Court also clearly says that a great miscarriage of justice is a ground for condonation of delay, Your Lordship. Your Lordship, I may be allowed to take you to the judgment, Your Lordship. Because if we are going to implement the judgment, Your Lordship, it is a direction to act contrary to the rules of 2010. Lordship, the judgment, page 25, this is the rules. Page 25, para 16, the relevant provision of Rule 19 of the ROP Rules 2010 are read as under. Rule 19, pension. 1, revised pension, family pension. We are concerned with pension. A, pension to be paid at 50% of the average emolument last paid drawn, which is more beneficial without linking to 33 years of qualifying service for grant of full pension, provided the employee's concerned has rendered a minimum pensionable service of 20 years. E, the pension, family pension of all existing pensioner, family pensioner, that is person growing pension, family pension as on 31/5/2008 shall be consolidated as on 1/6/2008. Then 4, this is important, Your Lordship. The amount so arrive will be the revised basic pension, subject to the provision that the revised pension, family pension, in no case shall be lower than 50%. In our case, it's 50%. 30% of the sum of the minimum of pay, Your Lordship. Sum of the minimum of pay in the pay band and the grade band, thereupon corresponding to the pre-revised scale pay, Your Lordship. That is 50% of the minimum of pay band and grade pay of the pre-revised, Your Lordship, because the petitioner, he retired in 2005. Because this clause is very important, Your Lordship. The amount so arrived will be the revised basic pension, subject to the provision that the revised pension in no case shall be lower than 50% of the sum. Yes, of the sum. Yes, this is, so Your Lordship.
Case shall be lower.
Lower, yes.
50%.
Of the sum of.
Does not rule out the possibility of higher.
Yes, yes. So this is the rule, Your Lordship. What the finding of the learned single judge, Your Lordship, page 44. Page 44, para 48. In the result, I find sufficient merit in this petition, and accordingly, the same stands allowed. By amendments of this court, the respondent number 3 and 4, they are the Accountant General, are directed to refix the pension entitlement of the petitioner to 50% of the revised basic scale of pay of rupees 54,600, Your Lordship. Corresponding to pre-revised pay scale, there is no 54,600 of the pre-revised, Your Lordship. So the learned single judge, he has directed this respondent to pay the petitioner the pension as per the revised scale of pay, Your Lordship.
Where from he has got the figure?
The figure, Your Lordship, that would be by appeal.
No, in a judgment, it might have been mentioned, otherwise he cannot take it out of thin air. Yes, it is there. Paragraph 19. Fitment table.
Yes, paragraph 90. But Your Lordship, this fitment table is this is an incorrect one which he has recorded. Because as per the fitment, Your Lordship, that is at
Okay, table 20.
table
Is it wrong?
20. Yes, this one is because 54,600 is the revised, Your Lordship. Page in my appeal, Your Lordship. Page 50. This is the ready reckoner, Your Lordship. Page 50.
He has referred to ROP rules, table 20.
Yes, so the table 20 is in
Where
the
is that
next page.
annexer 3? Annexer 3.
The next page, Your Lordship. The next page.
51, table 20.
Yes, table 51. This is the ready reckoner. Table showing the amount of revised minimum pension, family pension at ordinary rate of pre-16-2008 pensioners, family pensioner for post carrying corresponding pay band and grade pay under the Nagaland Services ROP Rules 2010 with reference to Finance Department such and such 5/5/2015. Table 20, Your Lordship. The first column, S20, Your Lordship, grade. This is 16,400, 500, 20,900. This is the scale of pay where the petitioner retired. So the pay band will be 9,900. And the sum is 49,550. And the fifth table, this is 24,795, which has to be the petitioner pension has been revised and he is getting this pension, Your Lordship. Because if we read the column, the top column, minimum pension, 50% or sum of the minimum pay in the pay band and grade pay, minimum pay as per fitment table,
So
column
you,
4, Lordship.
so you say
Yes,
20,900 cannot be translated to
yes, 54,000,
600.
yes, Lordship, yes.
What should be the figure? 49,590.
49,590.
Yeah,
That was the
then
pre-revised,
50.
yes. So now we have petitioner pension has been accordingly step up to 24,795 because this is the ready reckoner, Your Lordship. Yes. Whereas the learned single
Annexer
judge.
3. Where is that annexer 3?
Annexer
Affidavit in.
Page 96.
Huh?
Page 96, by the way. Page 96 of appeal memo.
Is 51?
Page, Your Lordship,
51. That's why we have cautioned this.
page
They have
96.
just found only the minimum part.
Your Lordship, this is the revised one. Page 96 is the ready reckoner for fixation of pay under Nagaland Service Revision of Pay 2010,
Is it
table
a state
20.
publication or private publication?
It's a state publication, Your
State
Lordship.
publication.
Yes, yes. But Your Lordship, 2010 is applicable, revision of pay is applicable only to the existing employees. Petitioner retired in 2005. So when he retires in 2005, his pension is
Lordship, the stand of the Accountant General Lordship, as far as this case is concerned, the 2000 RP of 2010 will be applicable with effect from 1/6/2008. Petitioner retired in
in
2005.
2005.
So question of giving in 2010 ROP does not arise, Lordship. Even for that matter itself. Because he retired way back in 2005, March.
Otherwise, Mr. Meju, from common sense, I am asking,
Lordship.
that pension of petitioner,
Lordship.
which he was receiving after retirement,
Mm.
was relatable to a pay scale,
Yes.
right? Then, after 2008, his pension will be relatable to his earlier pay scale or the revised pay scale. Simple question
It
I'm
says
asking.
50% of the pre-revised scale of pay, 50% of the pre-revised.
Well, then it will be peanuts, 10,000.
Your Lordship, here, the ROP Rule 2019, it clearly says, which I have read, it clearly says 50% of the pre-revised, Your Lordship. That is a page 16. In the judgment, that is at page 126 of the appeal memo, page 126.
Internal page,
126, Your Lordship.
internal page, because here there is no pagination. So it's in the judgment. Is it tell me?
Para 16, Your Lordship. Para 16, this is Rule 19. This is pension, the column 4. Number E. E. The pension, family pension of all existing pensioners, family pensioner, that is person go drawing pension family person as on 31/5/2008 shall be consolidated as on 1/6/2008. 4. The amount so arrived will be the revised basic pension subject to the provision that the revised pension, family pension in no case shall be lower than 50%, 30% of the sum of the minimum of pay in the pay band and a grade pay thereon, corresponding to the pre-revised pay scale from which the petitioner had retired, from which the pensioner had retired, died. So, Lordship, it has to be as a 50% of the minimum of the pre-revised scale of pay, not the revised. Because 2010, the ROP initially, it was not applicable to the petitioner. Only in 2017, an office memorandum was issued where the petitioner 50% of minimum of the pre-revised is to be granted to the petitioner.
Now
Lordship.
come to page 51 again.
51. This is the ready reckoner for the pensioners.
Page 51.
Yes. Lordship, this is table 20, 16,400. This is grade and pay scale with effect from 1/6/1998, the first column. The second is name of corresponding pay band scale, grade pay under Nagaland service, revision of pay 2010. Then sum of minimum of pay in the pay band and grade pay as on 1/6/2008 as per fitment table given at Annexure 3 to Nagaland such and such. That is 49,590. Then the next is minimum pension, 50% of sum of the minimum pay in the pay band and grade pay minimum pay as per fitment table column 4. That should be 24,795. So accordingly, the petitioner was getting at that moment 23,650. So in view of this revision, we have stepped up his pension to 24,795 because this is the ready reckoner, Your Lordship. So, Your Lordship, there is a grave miscarriage of justice. So it is
Okay,
itself a continuation of delay.
We condone the delay.
Lordship.
But Ms. P. Shukri and additional advocate general for the applicants, and Mr.
N.K. Likhamal.
N.K. learned counsel for the opposite party number 1. Opposite party versus number 1. Who was the writ petition? Also heard Mr. M. Mojul and counsel for the non-standing counsel, accountant general, A&E Nagaland for the respondent number 2 and 3.
Performer respondent.
Performance. The instant application under section 5. of the Limitation Act 1963 is preferred by the applicant who has
Oh, Vivek,
uh,
this data.
applicants seeking condonation of delay of 100 days in preferring the accompanying appeal to a sale, a judgment and order dated
10/6/2024.
10/6/2024, passed by the learned single judge in a writ petition, WBC number 281 of 2022. Full stop. Para. We have gone through the statements and averments made in this interlocutory application. More particularly, paragraph 2, paragraph 4. Thereof, full stop. We have also gone through the objection filed on behalf of the opposite party. Number 1, writ petitioner. Full stop. Having gone through the statements and averments made in this interlocutory application, we have the view that the appellants have made out a privacy case showing sufficient cause for condonation of delay of 100 days in preparing the accompanying appeal. Accordingly, the instant interlocutory application stands allowed. The delay of 100 days preparing the accompanying appeal, writ appeal is accordingly condoned.
Content. I need to be listed after this one. So they best.
Okay, we'll the appeal. Heard. Miss V. Supri, learned additional advocate general, Nagaland, for the appellants. So learned counsel for the Madam, who is the first title in the appeal?
It's it will be page 1, right after list of dates, Your Lordship.
The body of the appeal memo. Okay. Learned counsel for the respond number 1, that's it, petitioner. Also heard Mr. N. Mojui, learned standing counsel, accountant general. A&E for the pro forma respondent number 2 and 3. So in this inter-court appeal, the judgment and order dated 10/6/2024 passed by a learned single judge in a writ petition WBC number 281/2022 is assailed. Full stop. In the writ petition, the respondent number, which was filed by the respondent number 1 as the writ petitioner, sought entirely a direction to the respondent authorities to implement the revision of pension of pre-2008 pensioners as per table 20 of Annex Roman 3 of the revision of pay rules, 2010 and the Finance Department's Office Memorandum dated 5/5/2017. Full stop. While allowing the repetition command under a single judge issued a direction to the state respondents to refix the pension entitlement of the petitioner to 50% of the revised basic scale of pay of rupees 50,600 corresponding to pre-revised pay scale from which the petitioner had retired in terms of the provisions of page para 40. Sub-rule 1E Roman 5 of Rule 19 of the Nagaland Services within bracket revision of pay rules 2010 with effect from 1/4/2010, which first of as part table 20 of the ROP rules 2010 and Finance Department's Office Memorandum dated 5/5/2017. Full stop. Ms. Sukri Lanate, Additional Advocate General, has contended that as per the table showing the amount of revised minimum pension stroke family pension within bracket at ordinary rates of pre-16/2008 pensioners stroke family pensioners, comma, the petitioner, the expendable one, this petitioner would be entitled to is eligible to get fixation of his pension at rupees 24 at rupees 24,795 on the basis of which is 50% of the minimum of pay in the corresponding band and grade, that is rupees 49,590. Right?
Yes, Your Lordship.
So otherwise it would be 27,000 as per the single judge judgment.
No, it will be higher, Your Lordship, because he has taken as per the revised
When
basic
you come
scale
to
of
page
pay.
48, he also has given 50% of the revised paragraph 48.
40, paragraph 40.
Refix the pension entitlement of the petitioner to 50% of the revised basic scale of pay of 54,600.
Where is Rule 19?
Page 155.
The rule 19, Your Lordship. It's at page 126.
Paging 9. There is no page
126.
Rule 19, Rule 19.
Para 16, Your Lordship.
Para 16 of judgment.
Yes. Or maybe imagine. 54 na kichukua 54,600. Of course, 30,000 plus 1,000. Yes, 30 plus 1,000. Yes.
Explanation there as well. Lordship, the explanation, you'll find it in page 63.
as far as the paragraph 16 is concerned, page 63 of the appeal memo. It's a letter written by the Accountant General Office explaining. Professor response is 63. Paragraph, second paragraph. As per the ROP notification, Lordship. The explanation is here. What the additional AG is trying to explain, Lordship.
This interpretation is for saving the money of the state.
In fact, Lordship, if the petition
Anyway,
the grant granted, you know, open up a floodgate.
after having heard the learned counsel for the parties, we are of the view that the matter would require further consideration. Admit the appeal is admitted. As all the parties are representatives, in defense of notice stands dispensed with. Considering the issue involved, list this appeal on 5/2/2025 till the time, till the returnable date, the operation will be. Admit appeal, same thing. Till the, yeah. It is observed that till the disposal of the writ appeal, accompanying writ appeal, the operation of the in judgment and order that is so certainly still. The interlocutory stands accordingly disposed of.
Much
You will run the risk of 9% interest.
For hearing, item numbers 9 and 10.
Willards, I'm appearing in for the appellant's notes in item 9.
Manus, I'm appearing item 10, Manus, connected matter for the appellants, supporting appellant in item 9.
Watching the judgment you are referring to, or the interim judgment, where can I find it?
Plus, the view judgment is at page 66 of the item 9.
That is writ appeal number 7.
Yes, plus.
66.
It actually starts from 63.
This is dated 2nd of June 2023.
Petitioner side is, petitioner side is represented by Mr. Poseco. You represent the original petitioners.
Lordship,
You were. People for. Sorry. Motivation with training chance.
Plus, may I take your lordship through the basic pillars whenever your lordship thinks convenient pillars?
Then we have to review two perhaps.
Very well.
Very well.
Already time for recess.
Very well, my lords.
This is listed there, 2017 nah. One unlisted nah. Kita be unlisted nah. Item number 16 la cost list mula tan hanai lo. Itu. Judgment reserve to kundo thakila. CAB item number 16 nah. So, 얘들 나도 니 원하는 거 좀 잠시대. Order passed. Nang nasib benar guys deh. Bisa bisa kina. Look, rough punai na. December BB.
Possible kan kota na.
Password बताना मुला क्यों हराई जबा
Oh, 16 as well.
yes itu biasa na
Huh?
supplementary lah lebih melalui
Oh, 17, itu BB lah.
tu melalui 17 juga na CB item number क्या है 16 ना oh item number 6 na number key number
Liability criminal fee.
24 which stage withdrawn na Withdrawn. Our next two item number.
7.
7 na.
Are you seeing 173 of 2024?
Admission.
Orders.
Good. Good. Orders. Yes. Yes, what's that?
2024.
173 of 24 na. Are with us na?
All of confusion that's why 174.
Because I see 174 भी कुछ नहीं है.
Let's see then
Allowed नहीं था. Same item there's na.
save it to 16. I'll go and find out.
Well, item number 7 is na.
That's not specified because because actually they are doing this or what argument is not been raised by the main respondent to this really silly. Main respondent raising what is real. Oh, No, Yo, award here. Oh, 6. Oh, 835.
Reports now, where's CAB na? Now we're not, it's 16, 17. 9 plus 7, 17.
03.
Needs be, this supposed to be just a thing that's any narrative. Refixation to charta aro budia bungu jole je 330 la Pushne asne ke isko to budia bungu jole isko na bole budia bungu ke am to ye de kurina ki budia bungu de ye de la case na bahar aso ye to level ki dila statement में बनाओ लाइन और ना इचार बनाना की दो
Local review stage of less.
statement there. One is na.
I don't know.
Kevin kami. Kevin kami likit dulu. Ye to nam kami.
Including state.
This was Lola. That's the one thing, huh? Hopefully, one thing in our head over there. In our head over. Aqui do outro lado. E do lado sim,
Statement. Overrun. These guys will be. Disposal is just to verify the information of anything. Maybe they do not going. Give it to the excessive. SP December visi लिखना है हमने पिछले बिजार Chinese Sanskrit disposal han सब करना किती जो यति करे so this we release again Take that one. So one is DCC. This is, so the rule says number will not be changed. Number change, how is it, if I take out the name, then. Oh. So 1.1 is the number. If there are only, there's one such part of it, one or more. More would to work for detention. Isso não sei, quando isso was a bit decisão, mas I'm represented by elements. So this is, and I shall, I think it tells with some laws. Aquele negócio não vai contra. Tu sempre te sabe, né? Não tem coisa. Isso, eu vai relaxar tudo. Não. This person is a legal identity for the system and social trial and children. It's a person. Not children, this is yeah, this is a 자기가 되게 말하는 거. Naya.
Plus, nah.
Ring của này thì một nó không phải cái số liệu là vừa rồi số liệu của người ta bên trên phiếu của người bên trên phiếu Keep right at your colored sheet nói let it hold
Nah, itu kas sekolah tadi. Kas sekolah anak itu pikir pada itu.
Just to open some file to second also issue. No.
What are all these?
Citation. It is second as well. You don't. Both the language. All halak residue. All. I'm ready to present my case. What's the whole? Oh. Item wise. I had already predicted from now after 50 years, she's only one. How many years am I going to have a week? Acts. That is acted by way of passing issue. Judge भी द्विता, सुप्रीम भी द्विता है ना? ना? सही तो? Tidak makan pensiun mari makan. Mistake crucial. Without tiffin any other election. Negotiation. Itu Rafael is the Gauhati forward. If one particular item can be banned, why not? So one by one.
Bitala case mga hardest steno bitala opore. Bita case hardest steno.
So you are here.
No, just warming up.
What is the review notification?
Because the impugn notification is at page 161. Because I can take your lordship through three documents. There are two issues below which are impugned. So let's go one by one, just three documents. So at page 186, if you can start with that, which is also impugned, is a circular by FSSAI, the Food Supply Authority.
180.
186 minutes. So, Milaj, here, if I may read it out, your kind attention is this is Milaj by the Food Safety and Standards Authority of India under the Ministry of Health and Family Welfare, Milaj, of 6th August 2014, which is also the subject matter, Milaj, of a coordinate bench's decision. I'll show that to your lordships also, Milaj. Your kind attention is invited towards Regulation 2.5 of the FSS Regulations 2011, wherein definitions of animals, carcass, and meat are given. As per Regulation 2.5.1, a animal means an animal belonging to any of the species specified below, ovines, caprines, sulins, bovines, and includes poultry and fish. The slaughtering of animals of any other species other than the one listed above is not permissible under the FSS Act and regulations. In view of the above, you are requested to kindly strengthen the vigil and ensure the compliance of the provisions of FSS Act 2006. This is the central government ballots by this 6/8/2014, which is also impugned ballots. Then, if your lordship would take page 160, that is a state cabinet meeting ballots. Dated 3rd July 2020, 160 minutes. The undersigned is directed to forward herewith an extract of the minutes of the cabinet meeting held on 3rd July 2020 for kind information and necessary action. Ban on import and sale of dog meat in the state. The cabinet deliberated on instances coming to light of import and commercial sale of dogs for their meat in the state. The cabinet observed that dog meat falls within the family of canine, which is excluded from the provisions of Regulation 2.5A of FSSAI Regulation 2011, which regulates and defines the meat sale and consumption, and thus the existing law does not permit the slaughter, sale, and consumption of dog meat in the country. The cabinet, after due deliberation, decided for issuance of orders banning the following: 1. Commercial import and trading of dogs and dog markets. 2. Commercial sale of dog meat in markets and dine-in restaurants. Necessary orders will be issued by the Chief Secretary in this regard, backed by relevant sections of law, and the same will be enforced by district administration, police, municipal administration, and the veterinary and animal husbandry severally as well as jointly. Action taken will be intimated to the cabinet cell. And then, my lords, With this is followed by a notification of the state by the CS at page 161. The next page over. This is issued by the Chief Secretary of the state, Millets. Ban on import and sale of dog meat in the state. Whereas the Central Government Ministry of Health and Family Welfare has enacted the Food Safeties and Standards Act 2006 and Food Safety and Standards Regulation for short to regulate the safety of food as articles unsafe for human consumption. And whereas in Regulation 2.51A of the FSSAI regulation, meat and meat products, and as per Regulation 2.5.1A of Regulation 2006, animal means an animal belonging to any of the species specified below. The same, my lords, has been extracted: ovines, caprines, suolines, bovines, and includes poultry and fish. And whereas the slaughtering of any other species other than the ones listed in sub-regulation 2.5.1A of the regulation are not permissible under FSS Act and regulation. And whereas for strict compliance of the FSS Act and regulation, and in order to regulate the safety of food articles safe for human consumption, it is necessary to ban slaughter and sale of dog meat in the state of Nagaland. Now, therefore, in consonance with the provisions of the FSS Act and regulations, the following are banned with immediate effect: commercial import and trading of dogs and dog markets, commercial sale of dog meat in markets, and dine-in restaurants. Any person found violating this order shall be punished under sections, I'm not getting one section, and 429 of the Indian Penal Code, and Section 11 of the Prevention of Cruelty to Animals Act, and or any such other provision of law which may be applicable. This shall be enforced by the district administration, police, municipal administration, and the veterinary and animal husbandry department severally as well as jointly. This is issued in pursuance of the approval of the cabinet by memorandum number so and so dated 4/7/2020, which your lordship saw, my lords, at page 160. Now, my lords, the challenge in the writ petition is at page 236. What is IPC provisions? If your lordship will take page 236, my lords.
Yes.
Let's here at page 40, internal 41 at 236. The prayer A is not to quash and set aside notification dated 4/7/2020, banning the commercial import and trading of dogs and dog markets, and B, commercial sale of dog meat in markets and dine-in restaurants, and correspondingly quash and set aside the cabinet decision to ban trading and selling of dog and dog meat contained in the cabinet memorandum number so and so dated 4/7/2020, and BB, which is the circular minutes, quash and set aside the letter dated 6/8/14, which is a circular by the central government. These are the three minutes, various documents of the government which have been sought to be quashed, which in effect, starting with the central government, which says banning of dog meat, sale of dog meat, commercial markets, etc., followed by the cabinet, considered by the cabinet. Thereafter, instructions to the CS, the chief secretary, who thereafter issued a notification, which in effect, in compliance of the laws, and the provisions of the IPC, hitherto IPC, now of course the new IPC has been superseded, but section 428, if I may just read out of the IPC: missing by killing or maiming animal of the value of 10 rupees. Whoever commits mischief by killing, poisoning, maiming, or rendering useless any animal or animals of the value of the 10 rupees or upwards shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. Similarly, section 429, as mentioned in the notification: mischief by killing or maiming cattle, etc., of any value, or any animal of the value of 50 rupees. Whoever commits mischief by killing, poisoning, maiming, or rendering useless any elephant, camel, horse, mule, buffalo, bull, cow, or ox, whatever may be the value thereof, or any other animal of the value of 50 rupees or upwards, shall be punished, which may be for a term of 5 years, up to 5 years, or with fine, or with both. Similarly, there are provisions under the FSSAI and the Prevention of Cruelty to Animals, which also make any violation of the provisions of the Acts punishable by imprisonment. And here your lordship will take section 63 of the FSSAI Act.
Section FSSAI.
Yes, that's Food Supplies and Safety Standards Act. So let's here, punishment for carrying out a business without license. If any person or food business operator, except the persons exempted under so and so, himself or by any person on his behalf who is required to obtain license, manufactures, sells, stores, or distributes or imports any article of food without license, shall be punishable with imprisonment for a term which may extend to 6 months and also with a fine which may extend to 5 lakh rupees. Now, I may just pause for a minute. As a matter of record, my lords, the writ petitioners do not have licenses under the Food Supplies Act. This is a matter, my lords,
Madam,
Food Safety Act.
yes, but if it is a say custom in the state of Nagaland.
Lords, we will respectfully, because I understand, my lords, the question is whether it is established custom or otherwise. That is also, my lords, some debate. But
Because in that case, it is Article 371A will come in.
because Article 371A, my lords, would not, for the reason that here, my lords, there is a statute which has been set in, and custom, my lords, in any case is not A, established, and B, my lords, there is a doubt, my lords, every country almost and every other state of the country in India has banned, my lords, this, my lords, follows the special provisions your lordship is mentioning under the constitution, my lords, would not, my lords, save violation of statutory law as made, my lords, and as applied.
Let us have a reading of 371A.
Yes, my lords. The Article 371A. And because may I respectfully state that this is not the subject matter of the judgment in the writ petition. This has not even been discussed nor relied upon in the impugned judgment. Special provision with respect to the state of Nagaland, notwithstanding anything in this constitution, no act of parliament in respect of religion.
An intra-court appeal.
Yes.
We can very well take it up.
Because I'm just mentioning to your lordship that this was not either argued, nor presented, nor it is a subject matter of any of the petitions, pleadings, or other averments in the current proceedings or in the proceedings before the learned single judge.
But if you see the judgment out there, more particularly at page number 83, 84,
yes,
they specifically refer to the customs of the Angami tribes, the Rengma tribes and all, wherein it has been construed to be that they have been having dog meat out there, and also that that dog meat have medicinal values. This is how it has been taken into account. So this would be a part of the customs if it is so.
Well, if I may go back to page 83, as your lordship said, even there the learned single judge, as I said, does not discuss Article 371A or saves it
not
on
required. We can very well take it up.
No, I'm just mentioning that. And then to come back to page 83, while below it is discussed.
Kindly page 90.
Yes, my lord.
Paragraph number 33.
Yes. So, my lords, here the court only says the courts, however, do not find any grounds not to accept the account of dog meat. Doesn't say it is customary, but not to accept the account of dog meat being consumed by different tribes in Nagaland. The word custom or otherwise, my lords, is not
religious and social practice.
My lords, religious and social practice, this could not be called a religious practice, I believe, subject to correction, my lords. And nor is, my lords, could be understood as such. And my lords, again, it could not be considered the social practice, nor has the court come to a finding that it is any of these practices after discussing, my lords. In fact, my lords, on the contrary, at page 25, I would go back to page 90, in paragraph O, because we have specifically mentioned this in the appeal, my lords. The respondents 1 to 3 have only relied on dated articles by English / foreign authors referring to the regressive custom and culture of consuming dog meat. The annexed references document the trend of eating dog meat and pork meat in the years 1921, 1926, 1937. No subsequent references have been filed by the respondent numbers 1 to 3 to support their stand. Not a single reviewed reference historical text supporting the custom and culture of consuming dog meat has been annexed by the respondent numbers 1 to 3. Millards, I would appreciate, Millards, I mean, my submission would be rather that the whole context, Millards, of Article 371A would only be read if it is any of these practices as stipulated under the Constitution to be entitled to a special status on that account. The finding of the learned judge, single judge, Millards, has been only that there are these accounts in books which mention this. It does not either hold it to be A, B, or C practice, Millards, of any form as contemplated in Article 371A. And
provided by the Legislative Assembly allows for FSSAI.
And then, Millards, if I may just go further, 371A, if your lordship will see, Millards, notwithstanding anything in this as an alternative, Millards, to what I was submitting earlier, and in addition, notwithstanding anything in this constitution, no act of parliament in respect of so and so, and if I may go further, shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by a resolution so decides. So, Millards, here in terms, Millards, the notification and the cabinet meeting of the state has in terms held that the FSS Act as direct, which is a central law and prevails over the country, shall apply. Because there is such a provision by the Legislative Assembly and by the cabinet, which is what has been enforced by the cabinet.
The cabinet cannot be equated with assembly.
That is correct, Millards. But the cabinet itself, Millards, in terms holds that the act applies. They are not making any law. The cabinet has not made a law. It only holds, Millards, that the law of the land, which is the FSSAI Act, Millards, applies, as also the Prevention of Cruelty to Animals Act, etc., Millards. And I will, Millards, at this point straight away come to a coordinate bench of this honorable court, Millards, reported in Hifzur Rahman Chaudhary on this count, Millards. It's a division bench judgment, Millards, and I believe one of your lordships was, Millards, a party to this judgment. So, Millards, my learned friend would be handing over the copies, Millards. And this deals, Millards, with cows, calves, camels, and other animals. So, Millards, here, the division benches, my Lord Justice Manesh Ranjan Pathak and my Lord Justice Manish Chaudhary.
That is in respect of state of Assam.
Millards, the issues are still the same, Millards. This same circular, the same government circular has been considered and has been held to be overriding, Millards, as enforcing law.
Sitting in the state of Nagaland now.
Millards, that may be so. But even so, Millards, Gauhati, Millards, I believe, is the principal, Millards, bench of this court, Millards, as I understand it. Anyway, Millards.
Article 371A, madam, that's the problem.
I'm sorry, Millards.
There you don't have the Article 371.
That your lordship is absolutely correct. Because I'm not saying so. But here, Millards, what I'm saying is
that here we don't have in Nagaland the Right to Fair Compensation Act.
Yes. Millards, but I'll take the lordships. I was arguing such a matter before the Supreme Court, Millards, relating not to Nagaland but to another state where the act didn't apply. And by and large, Millards, the Supreme Court has been holding time and again that such laws which are there, Millards, either for betterment of rights or for rights, Millards, have to be enforced pan-India, Millards. And therefore, Millards, we in fact lost.
No,
Let me put it in another way.
371A is a hurdle.
No, Millards, 371A would be a hurdle only in the event.
List now. There is a list also that whether Petroleum Act and all mines and minerals, all these act to be applicable directly unless Assembly concurs to it.
Because in this case, if the Assembly brings out a law, in this case, may I say, the cabinet by a cabinet meeting and by a notification has said that the laws which are currently in force will apply. So, my lords, those terms, my lords, the legislative assembly, my lords, I can address your lordships even further on that, my lords, I have no difficulty. But I would take it because this was not an issue raised. So I must say that I would need maybe a week's time to come back to your lordships, my lords, on that. But with due respect, my lords, the point is,
In a broad term, 371A, one is religious, second is social practice,
yes,
third is customary.
yes.
So, and at least we are aware that this meat is consumed during customary or their functions.
My lords, I would only, my lords, for the time being say this, my lords, that the learned single judge has not come to a finding that this is a customary practice. We cannot, my lords, go beyond what has been found. And if I may repeat, my lord, paragraph 33 at page 9.
This is a constitutional provision.
No, I am talking about this being a customary practice has not been established, my lords, anywhere. So, my lords, it cannot come out of the blue. Customary practice also, my lords, has to be established. What has been found at page 90 is only references to texts of 1921, 1926, and 1937. We are now, my lords, in 2024.
Page 97. Consumption.
Page 90, my lords, para 33. In terms refers, and I've taken this in the appeal, my lords. 90, line 5.
Social norm.
So it is not, this is the only finding of the court, that this has been found in the texts of 1921, 1926, and 1937. This, of course, I might mention are by Macmillan and Company, which are foreign authors. But
We think that normally custom does not change.
Miller's, your lordship cannot come to such a finding, I'm afraid. That may not be within Miller's the scope of the appeal, Miller's.
Ordinary.
A finding will happen, Miller's. Neither has it been pleaded, nor argued, nor found. So, Miller's, custom, your lordship, of course, can possibly consider outside the record, but not as a judicial finding. So, Miller's, with respect, I don't see, Miller's, how to address this in a context of a position where it has not been held to be customary practice. In the absence of that, there is nothing, Miller's, to be argued ultimately on Article 371A. And I would, Miller's, make myself good on the fact that the cabinet meeting ultimately endorses the existing law. Miller's, what is in any case, Miller's, in today's world, I think safety, Miller's, cannot be bypassed by anything, even custom.
We don't know, subject to, you come up with that because here it says the finding is, the observation is a belief. Belief.
Belief is not custom.
Dead meat is also having medicinal value.
But my lords, such is the belief. But the entire act, my lords, FSSAI.
Otherwise, this
belief
figure
is-
33,
I'm sorry.
the court has observed on the basis of some authority. It is not that.
No authority. It is only on text. Text is
What do you say, authority then?
of which year? My lords, 1937 last.
So it is a long custom.
Where does your lordship find the fact that it has been carrying on, let us say, 2020? Is this or 2010 or 2000 or 1990? Every country, my lords, in the world has banned. China has, South Korea has.
Who has produced that book?
Yes, my lords.
I did. The book, it's not with me, the hard copies. It's not with me at the moment.
Show me the book. Where from? If that finding is not there.
Yes. Actually, I did not produce, but I had extracted the relevant content from the books.
Get the book.
If your lordships require a book, then
Otherwise, an extract
yes.
can be picked up from anywhere.
Or if we have the net facility, then I have also provided the link from Internet
Do you have
Archives.
the book or not?
The hard
You have
copy
to
not
see
with
it
me.
is
At the
in
moment, not with
existence.
me. At the moment, not with me.
My lords, may I also say that the Nagaland, my lords, website on health also holds, my lords, that the Food Safety and Standards Act applies and is being implemented in the state from 2012.
If it is being adopted,
I'm sorry, Miss.
Madam,
Yes.
have you adopted the Food Safety Act?
Adopted by the,
The-
when it has been adopted by the Nagaland Legislative Assembly by resolution. On that issue, I have no
That it is
idea.
very
But
easy.
yes, but Lordship, for that matter, I can get an instructions. Yes, I just text the secretary also, but I didn't get
Because
the.
if you get that it
Yes,
has been
yes.
passed by resolution by the assembly, then it is,
Mm,
that notification will apply.
mm,
If
That's
you-
right.
mm,
I'm grateful, Manoj.
Right.
yes.
So let us have the instruction and madam.
Of course, Manoj, of course. I will also, Manoj, get it from the other side, but in the meantime, the state may respond, Manoj, is more appropriate.
Ah. But we will be closing for holidays.
Yes, Manoj, we all are. So your lordship will keep it in the first week of January or somewhere near there, Manoj.
No,
Second.
no, not January. It will be reopening date will be 16th January.
Very well, Manoj. Then after that, Manoj.
After that. And normally in Kohima banks, the division bench sits on Wednesday.
I believe so, Manoj. I believe so.
It may be kept on Wednesday.
Let it be kept on Wednesday. That's 22nd January, is that, Manoj, possibly?
Yes, we are admitting both the appeals.
Yes,
for
Manoj.
hearing.
Yes. Let's just keep it on the top of the board, Manoj. It will be very grateful to be able to finish off. 22nd, if that is convenient to your lordship.
Okay. Heard MS Pinky Anand, Planet Senior Counsel for the appellants in 9. And Mr.
Manish Singhvi, sir.
Manish Singh, Planet Senior Counsel for the appellants in 10. Also heard Central Government Council,
Before the respond, 1 to 3 in item 9.
Mr.
L. Iral.
N.
L. Iral.
L. Iral. Council for the respondent number 1, 2, 3 in 9. Or respondent number 1, 2, 3 number 10. Mr. Learned Council for the respondent number 1, 2, 3 in 10. Mr. Okay.
Your Lordship, I'm for respondent number six.
Assisted by Mr. Fonseca Kote.
Lordship, I'm assisting Ms. Pinky Anand.
Okay. And Mr. Singhvi, you are assisted by anybody here?
Yes, my lord. Council must be there, man.
So, Singhvi. Okay. Central government,
Your Lordship, I'm for respondent number 7 and 8.
Mr.
YP Gupta.
YP Gupta, Learned Central Government Council for the Union of Indian Respondents.
Lordship, I'm for respondent number 6 in both the appeals.
Mr.
For respondent number 6.
I Longjam,
Yes, Lordship.
Learned Council for the respondent number 6 in both the appeals.
Yes, Lordship.
After having heard the Learned Council, the Senior Council appearing for the appellants, we found that the matter would require some consideration, further consideration. Both the appeals are admitted for hearing as all the parties are represented and as agreed to list the appeals for hearing on 25th.
22nd, Lordship.
22nd?
Yes. This is the
Yes,
Wednesday.
22nd is a Wednesday.
22nd.
That's top of the board.
January 2000, that I don't do. 2025 was the Miss Sukri, also had MSP Sukri Learned. P. Sukri Learned Additional Advocate General Nagaland for the state respondents.
Let it be recorded, Manoj, that the state will come back with instructions on.
Yes, I'm telling.
Whether they have passed a resolution or not.
That is, yes. MS Sukri Learned Additional Advocate General Nagaland shall obtain instruction as to whether the Legislative Assembly of Nagaland has adopted the Food Safety and Standards Act, 2006 by way of a resolution. And such information is to be placed, instruction is to be placed on the next date of listing. Mr. So-and-so learned and Al Iralo learned counsel representing the respondent number 1, 2, and 3 in item number 9 shall produce an authenticated copy of the books. All the books relied upon by the petitioners before the learned single judge, as referred to in paragraph 33 of the impugned judgment. 22nd.
Obliged.
Obliged, Your Lordship. Obliged, Lordship.
For hearing, for hearing, item numbers 12 and 13.
Conviction under
Section 20B, subsection 2C. The punishment is 20 years maximum. Or should we see page 67?
NDPS.
NDPS, my lord. Page 67 is the judgment. By this judgment, dated 17/6/2020, the special judge.
Page 67.
67, my lord, on the page. The special judge Peg has convicted accused 1 and 2.
Accused 1 and
And
2.
2, my lord, for a term of 15 years.
15.
15 years, my lord. May I read the judgment, my lord? Next page 68 is the 11th page. Judgment.
Where is the FIR?
My lord, yeah, page 14. Page 14, my lord.
Page 14.
May I
Yes.
read it, my lord? Yes. To the official in charge police station. Kejakino. Subject FIR, sir. I, ASI Selu Koza, officer of police station, report before you stating hearing. Stating herewith that on 30 May 2018, at around 22:30 hours, I received reliable specific information from sources that a huge quantity of contraband articles like ganja had been kept inside a house in Lowaza village. So immediate right was required, otherwise the consignment would have leave the spot public place. I entered this information in the Procedural PSGD and informed OC Procedural and SDPO Procedural, and along with one
lens knife, misosoil, and 2 lens knife over there, 3 UBC so left for the spot in SDPO Federal vehicle. The house was located below the main road of the weather village. On reaching the house, immediately party personnel surrounded the house and asked the owner to open the house. I gave my identity to him and asked the owner of the house to disclose his identity. I told him that contraband ganja has been kept inside his house and needs to be searched. He was fumbled. I intimated him his right to be searched in front of a gazetted official as per provisions of section 20, model 50 in Act. Therefore, myself, SDPO, and the team, along with independent witness, gave their personal search and also the house. During search of house, 45 packets within bracket 450 gram, a kg of plastic bags were found in one of the rooms. On checking the bag, it was found to be packed with contraband ganja. The recovered ganja was shown to SDPO and witnesses. The said owner said he was keeping the ganja in his house with his own knowledge, and the said consignment belongs to him. That is Kapalo Sara, aged about 56, son of so village Leshimi, present address Lawaza and Apollo. Therefore, the items were seized and sealed in the presence of gazette official and independent witness, and serial list was prepared. As the accused one was found in exclusive and conscious possessions of 450 kg of ganja in his house, he committed an offense under section 20B to Roman 2 Clause C NDPS Act. Therefore, arrested him at 23 hours, explaining the grounds of his arrest after observing all formalities of arrest. I, along with the writing party, came to Procedural police station with the accused and seized the 45 packets with 400 kg of ganja and marker.
Whether ADC means magistrate.
My lord.
Page 33 of the paper. Para 8.
Page 33, madam.
Para 8. Made to ADC.
Yes, ADC.
Kutsero.
Kutsero.
He is magistrate.
No.
Huh?
No.
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 And during trial, what was produced?
See?
Where are the exhibits? Exhibit.
See last page, exhibit, it is an next, last page, 78, last page. Madam. This is part of the judgment. Exhibit 1 is property search and seizure memo, seizure forms / arrest or surrender form. Exhibit P1A, signature of seizure witnesses. Exhibit P.
Where are the material exhibits?
My lord, lordship will see.
Okay, it's not there.
Nothing was exhibited.
Photographs of
That's
accused.
what I'm going to count, because.
Let us see the photographs. 47.
Yes, ma'am.
Page 47.
Page 47 and 48, my lord. Except these two, nothing is there.
Hmm?
Except these two, nothing is there.
This is the exhibit.
Also, we see page. My lord will see exhibit P5.
Page 50. Where is the certification of magistrate?
Nothing. I'm going to come there.
Huh?
In
Not
this
there.
case, in this case, my lord, no independent witness, no certificate under section 50, nothing was exhibited before the court, these articles. And then even the seizure memo,
And remnants of the sample was also not
Nothing.
exhibited.
nothing, even in the seizure memo,
Inventory,
no signature.
there
of-
was no inventory.
No, nothing. I'm coming to that. Nothing. So.
No inventory,
Nothing.
no certified
Nothing.
list of samples,
Nothing,
no remnants
Nothing.
of sample,
nothing, no.
then
independent
no, neither the seized contraband.
Seized articles were not exhibited. And then, like I said, my lord, most important in the experience character, seizure memo is important. In the seizure memo also, signature from whom this article was not appended, nothing. If lordship see the seizure memo, quite interesting.
Where is the FSL report? Page?
46. Page. 46, my lord. And expert also not examined in this case. And now expert was also not examined.
Not
Was
examined.
Not examined. Also will see the report, I'm coming to that. The report says that 3 sealed brown envelope marked as NHA A, B, and C containing some plant materials packed, some plants. When we go to definitions of NDPS Act, definition 2, plant is not NDPS, not ganja. If we go by definition 2, it has to be flower and it stops. Plant is not ganja.
And who is this, before whom it was drawn?
Nothing.
Document.
Why not the SDPO, who was part of the writing team?
Who is the witness?
SDPO. If
Witness.
Lordship, independent witness,
No. Anybody saying about drawal of samples?
nothing. There's no evidence at all. No problem at least in this case, no provisions of NDPS is followed.
There was no material exhibit.
Nothing,
There was no exhibit of the remnants of the sample.
nothing, my lord.
FSL expert was not examined.
No independent witness,
And okay, then inventory was not examined,
no.
produced.
And
Photographs certified by the magistrate, no.
no.
Yes.
I don't have much to say, but let me put it this way, but there is some infirmity in the judgment passed by the trial court.
If the infirmity in the whole investigation and violation of the provisions of NDPS Act.
The trial court belongs section 25.
Sir, where is that the actual contraband during the trial? Where is that contraband?
He mentioned it at paragraph number in PW6. Says about it.
In the list of exhibits, where is the material exhibit? Not a remnant of the sample also.
Never.
List of drawal of samples. That was also not certified. No inventory was prepared. Where is the mathematics? If the suppose the inventory sample is not there, yes.
Can I divide the exhibit sample?
No, it is not there.
Today, and I'm able to obtain.
Not marked as an exhibit, material exhibit. Ah,
Yes, the state got 450 kilos of that.
right. Mr. Ajo. Learned counsel for the appellant in 12. And Mr. MS Netio Koja, learned counsel for the appellant in 13. Also heard Mr. KV Angami, learned public prosecutor for the respondent state of Nagaland. Arguments are heard, judgment is written. Had it been in the previous week, we would have delivered.
For motion. For motion from the supplementary cause list. Unlisted motion, item number 17.
If you have any copies of the judgment, you can find it.
And referring to which, Mohanlal.
Yes. That is your logic. This petition had been withdrawn last Friday, and then I had a fresh petition. Accused was arrested for possession of substance under NDPS Act on 6/7/2024. Now, while under by the local police in Dimapur, while under the custody, detention order was issued on 29/8/2024. The order is at page 26 of the petition. The detention order. The relevant portion would be paragraph 4, Your Lordship, the grounds. If I may be allowed to read, Your Lordship. And whereas I, Sonia Singh, Special Secretary, Home Nagaland, specially involved under Section 3(1) of the Prevention and ETC, Traffic in Narcotics, Drugs and Psychotropic Substance Act 1988 as amended, and satisfied on the careful examination of the proposal of the detention of Ms. Sarah Songyu, wife of Shangnam, wife and so and so, Innocent, Tamar Bazar, and being satisfied that with a view of preventing her from engaging in illicit traffic in NDPS, it is necessary to detain her. The next page will be the grounds of detention, Your Lordship. The grounds of detention. The relevant one will be the point number 4, Your Lordship. That if at large or if belt would be a threat to the peace and security of the state of Nagaland, and there is likelihood of you committing breach of peace and tranquility of the state, thereby endangering the lives of many innocents, peaceful existence of citizens, and many warrant law and order problems in the state.
It was a commercial quantity.
Yes, Your Lordship. But I was already under the custody. And I have not filed any bail application, or I was not under the bail.
Returnable 22nd. Art. Mr.
Lordship.
Im Chen, learned counsel for the petitioner. Mr. KB Angami, learned public prosecutor for the respondent number 1 and 2, and Mr. Jed N. Guli, learned central government counsel for the respondent number 3. The petitioner herein has assailed his preventive detention under the full form PIT NDPS Act 1998. Full stop. By. Not full stop, by. Page.
The detention order, Lordship, page 26.
Page 26. By an order dated 29/8/2024, passed under subsection 1 of section 3 of the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988. Full stop. Let notice be issued. Full stop. The notice is made returnable on 22nd January 2025. As the matter is of private preventive detention, the State Council, learned public prosecutor, the respondents shall file their counter affidavits invariably on or before the returnable date. Learned public prosecutor shall also obtain okay, 20. As Mr. K. Angami has appeared and accepted notice on behalf of the respondent number 1 and 2, and Mr. Nguli, the Central Government Council, has accepted notice on behalf of the respondent number 3, issuance of formal notice to the respondents and participants suit. The counsel for the petitioner shall, however, furnish requisite number of extra copies of the petition along with annexes to Mr. Angami and to Mr. Nguli within by tomorrow.
Yes.
By tomorrow. Post. Then the learned additional public, the learned public prosecutor shall obtain the relevant records and place the same for perusal of the court on the next date of listing.
Necessary.
Yes,
Lordship, item number 4, Lordship, admission.
yes.
Lordship, the hearing has been concluded, Lordship.
No, no, I have asked.
Only the instruction, yes. So if this matter can be upgraded to right after the motion, Lordship.
Actually, I have been already 3-4 judgments today. I have to, you have to see my
Yes,
situation.
yes, Lordship.
And from tomorrow, my brother will not be available.
Lordship.
Okay, let the motion be complete.
Lordship. Lordship.
For motion, item number 1.
Fabulous Lordship.
Yes.
Lordship, the petitioner is serving as marketing specialist in Central Institute of Horticulture at University of my Lordship, CIS. Now, Your Lordship, in CIS, there are 17 sanctioned courses.
What is CIS?
Central Institute of Horticulture.
Hmm.
Central. There is under the Ministry of Agriculture, Lordship. And in CIS, there are 17 section courses. But out of the 17 section course, Your Worship, only one post, that is the post of director, is filled up on regular basis. For the remaining 16 other posts, including the post held by the petitioner marketing specialist, Your Worship, regular selection process is conducted by way of advertisement, but appointment is made only on contract basis and on fixed pay, Your Worship. Now the petitioner is before Your Worship, as he has been appointed through a regular selection process by way of advertisement, Your Worship, and has been in service for more than 15 years now. Okay. So the petitioner is before Your Worship, seeking for a direction to the rest of the Your Worship to regularize his service. That is the case, Your Worship. Now, may I take Your Worship to the NA, page 15. This is an actual one, Your Worship. Now, this is the advertisement and serial number 3, Your Worship. Marketing specialist, one post is there, Your Worship.
Yes.
Now, may I take Your Worship to page 17 and lecture 2. This is minutes of the screening committee. Now, here, Your Worship, in second paragraph, about the advertisement made. For
So 29 applications, 11 were found suitable for interview, and amongst those 11, you were selected.
Advertised in this thing, this is advertisement.
Okay.
And then.
At this stage, we can issue notice.
Lordship.
Heard Mr. TV Jamir, learned counsel for the petitioner, and Mr. MS.
I'm appearing on behalf of Mr. Gauhati,
MS. Learned counsel representing Mr. Interim, learned
For all the respondents.
Central Government Council for all the respondents. Full stop. The petitioner, in this repetition command, the petitioner has projected that the respondent Central Institute of Horticulture, CIH, initiated a selection process by way of an advertisement dated 13/2/2019. 9. for filling up a number of posts, including a post of marketing specialist. Post of, as per the advertisement, the appointment would be made, appointments were to be made on contractual basis for a period of 6 months or till regular appointments were made against the post, whichever was earlier post of. In response to the said advertisement, the petitioner submitted his candidature for the post of marketing specialist, which required a qualification of Master of Business Administration from a recognized university or equivalent and experience in the field of so-and-so, page 15. In response to the said advertisement, a total of 29 applications were received. And a screening committee, after scrutiny of applications, found 11 number of applicants suitable for interview. And accordingly, those 11 number of candidates were called for interview. After the interview, the selection committee recommended the name of the petitioner for the post of marketing specialist in the pay scale of 18,000 to 22,000.
Not skill, which is a fixed pay.
Okay. And at a fixed pay of rupees 18,000.
Page 25.
18,000?
18,000.
On the basis of the said recommendation, the petitioner came to be appointed by an appointment order dated 27/11/2009. Post of. Since joining as a marketing specialist pursuant to the appointment order dated 27/11/2009, the petitioner has been continuing in the post of marketing specialist in the CIS. Post of.
Your Lordship, I have submitted representation for absorption regularization, page 30.
A representation was submitted by the petitioner seeking his regularization stroke absorption in the
Page 30. This is joint representation, Your Lordship.
in a post of marketing specialist, as no action appears to have taken by the respondent authorities. The petition
And
has.
Lordship, I have one more submission. Even in this petition, I have stated, Your Lordship, this is covered by in writ petition 38 and link is 39. If that may also be reported.
Will approach this court by this writ petition seeking a direction to the respondent authorities for his absorption stroke regularization in the post of marketing specialist. Post of. It is, Mr. Zamir has submitted that the case of the petitioner is covered by a judgment and order dated 27/11/2024, passed by a coordinated bench of this court in a writ petition, WBC number 38 of 2023.
And link is next page. And link is 39.
And
Link is 39.
WBC number 39 of 2023. Post of. Issue notice returnable on 31/1/2025 as MS so-and-so, representing Mr. Yangarvati, Learning Central Government Council, has appeared and accepted notice on behalf of all the respondents, issuance of formal notice as it is specified. The Learned Council for the petitioner shall have a furnished requisite number of extra copies of the writ petition along with annexes to and a copy of the judgments and order dated so-and-so.
They were also a party to that same still Lordship.
We didn't do working days from today.
We didn't do this.
2 days.
Lordship. And Lordship status quo as on today. As per the last extension order, my period is till January 13th, Your Lordship. So status quo as on today. I am still continuing, so status quo.
As the petitioner is continuing in a post of marketing specialist in the CIS as on date, the status quo as on today, we maintain till the next set of listing, the any continuation of the order will be examined on the next set of listing.
For motion, item number 2.
Same case, Your Lordship, here the post is horticulture specialist.
Horticulture,
Yes,
since
yes.
I have dictated number of applicants, so I have to say in the earlier master degree to
Now-
degree qualification to master degree in agriculture, page 21 or say in horticulture, followed by PhD. Where is the advertisement?
Initially, Your Worship, page 17, presently serving as a horticulture specialist. This is the advertisement. And here the advertisement is for the post of consultant technical, Your Worship,
Consultant technical.
as
Okay.
technical.
Marketing specialist.
And then recommendation, this one,
Qualification was MSc horticulture, huh? Chemicals, page 17.
and recommendation, page 19. Second para 2, petitioner, serial number 2. Miss Mary-
11 applications were received, huh? 11 applications, 8 were interviewed.
And then appointment as consultant technical, page 20.
Appointment order 9/1/2009, page 20. Your Meribeni City
Yes, Your Worship.
consultant technician.
And page 21, the same advertisement, Your Worship, as in the first item.
Right.
And here the post is, in the first petition, the post was at serial number 3. Now it is serial number 4.
Assistant
Horticulture
horticulture
specialist.
specialist.
So she applied for this.
Qualification like ours.
And the same minutes of the screening committee, page 23. And same
Recommended your name.
same proceeding.
Oh, it will be after 24 number of applications were received. Scrutiny kori 11, 19 were found suitable to be called for interview. For how many posts?
Just for 3 posts
For 3 posts.
of assistant horticulture specialist. Type copy is page 24A. Now that same proceeding of interview as in writ petition, first writ petition. Page 26. At serial number 4. At selected candidate.
Appointment order, page 31. 20,000.
Yes, appointment.
Since then, you are continuing.
Yes, and then she has been again appointed as horticulture specialist, page 35. That is the next higher post.
By an order dated, appointment order dated 28/01/2023, the petitioner has been appointed in the post of horticulture specialist on contractual basis for 6 months at a consolidated pay of rupees 46,200.
Now, and since then I'm continuing.
And to the end, the competent authority conveyed its approval to the said appointment of the petitioner on 7/8/2024. Any representation?
Yes, Lordship. Representation, same representation in
Same,
page 38.
3/12/2020. Page 38. Absorption, regularization,
And same interim on starting.
same interim.
Apply.
For admission, item number 4.
Three, we fixed 3 meters. Others are Ready or what? Item number 3, ready? We're ready. But it will take me more hours. Yes, Mr. Bujui, can it be taken up tomorrow? No. This one? Mojui, and Mojui. For the petitioner. And Mr. V. Jimomi, learned junior government Progressan, Nagaland. For the response number 1 to 6. Are present. First of them. Mr. Bendang Wabang, learned counsel for the petition, response number 7 to 11. With your good data. MS Mr. Jimomi has placed a letter dated 10/12/2024 from the Deputy Commissioner, which contains the instruction in reference to the order dated 9/12/2024. Full stop. List the case tomorrow. For admission, I don't know if I'm not possible to be taken up today. I don't. It may go to the vacation, not possible for me. Not be possible for me. Because
Another method fix before my road tomorrow.
maybe I don't know, because my brother will be leaving tomorrow because of hospitalization of his mother. So some difficulty, sudden difficulty. Otherwise, I'll hear this matter, but your matter will be deferred. Not possible, because I have reserved judgment for 2 criminal appeals, 1 habeas corpus today. My brother is having 2 habeas corpus and 1 more. Okay.
It may be listed after the vacation then, man.
Lordship, then kindly a date may be fixed.
Native Poja, Land Council Board of Petitioner, and Mr. Nangami, Land State Council are present. Where the case be listed on
23, man.
23, okay, 23. January. Because it is 2016 matter. I'll take up this. Others are 2024.
First of all, my senior, I'm led by my senior Ajo. However, he has one receive a beer at 3:30. That's why I'm appearing now.
Yes.
Well, my senior counsel was saying that this case can be disposed of without going into the merit also. However, my lord, it has to go into the merit because there is a difference in the judgments that has to be referred. So it has to go into the merit. However, my lord, I'll just take a short time in explaining the facts of the case because it is an admitted fact. It is an admitted fact. So I may not waste much time on the facts of the case. My lord, the petitioner herein is challenging the appointment of the private respondent number 6 on the ground that the rules of the game has been changed after the game is over. So, my lord, this matter, when this matter was heard on 4/8/2017, an order was passed to the effect that this matter, since the judgments that the petitioners were relying has been referred to a larger bench, so it has to be listed after the disposal of that referred matter. So thereafter, that referred matter has been disposed by the Constitution Bench of the Apex Court, and this is how it is been listed. Here, the private respondent numbers, there was an advertisement. My lord, I'll just take your lordship to the advertisement directly. My lord, it's it page number 19, annexure C, page number 19. Allow me to read it. Applications are invited in a plain paper, giving full curriculum, right from the serving candidates belonging to Chang, Kemnungan, Honyap, Thom, Sangdam, and Yangchumur tribe of state of Nagaland to fill up a post of secretariat assistant in the scale of pay of rupees such and such, grade P of such and such, under the establishment of Governor Secretariat, Nagaland, Kohima. The application should be addressed to the Commissioner and Secretary to the Government of Nagaland, Governor Secretariat, Nagaland, Kohima. Terms number 1. Minimum qualification, graduate in any discipline from any recognized university. 2. Candidates should have good working knowledge in computers. 3. Age not less than 21 years as on 31st October 2015 and not more than 30 years as on 31st October 2015. Age relaxation of upper age limit as per existing policy of the state government, including those serving in the state government. Next, the no objection certificate duly signed by the head of the department with name and official seal indicating the date of initial appointment of the candidate is required from applications already serving in the state government. Next, candidates who are already in service in the identical pay of rupees such and such will be given preference. Next, candidates working on fixed pay are not eligible to apply. Next, the date and venue of the written test will be intimated to the shortlisted candidates. Next, the applicants are requested to.
Not necessary.
Yes, madam. So this was the advertisement. Thereafter.
No, it is their examination.
Yes, my lord, examination, written examination, MCQ of total 100 marks, 50 marks written and 30 marks oral, and 20 for work experience. Subjects will be general knowledge, test of reasoning, simple arithmetic, and general English. Last date of submission was 15 December 2015. Thereafter, the petitioner and all the applicants submitted their applications. And my lord, if my lord may kindly turn to page number 19, calling letter was issued. Calling letter was issued.
Advertisement is page 19.
Yes, my lord. Advertisement is page number 19. And thereafter, calling letter was issued. This is 8 February 2016. My lord, I may be allowed to read this because there was some change in this calling letter. However, the petitioner is not aggrieved by this because this calling letter was issued prior to exam, prior to written test. So I'll just read out to Miss such and such. Call letter for written examination for one post of secretariat assistant and the governor secretary Nagaland, Kohima. Madam, in pursuance of this secretariat advertisement number such and such, and your application submitted in this regard, you are hereby asked to appear for a written examination on 16 March 2016 at such and such, hall of such and such. Your roll number is such and such. Clause 3. In a partial modification to these secretariat conditions in the advertisement, the written examination shall be for a total of 200 marks. Earlier, as per the advertisement, it was 100 marks. Now it has 200 marks. 150 marks for multiple choice question and 50 marks for subjective type question. 4. The written examination shall be for 3 hours. 5. The written test shall include the following topics, such and such. My lord, allow me to escape that one. Clause 6. The top 15 candidates will be shortlisted for an oral interview, provided we have obtained minimum of 50% in the written examination. 7. The final selection of the candidates of those called for interview will be done as under. Number 1. Total marks obtained in the written examination out of maximum of 200 marks shall carry a weightage of 60%. Oral interview shall carry a weightage of 30%. The overall assessment and such as work experience, knowledge, proficiency in computer, educational and professional qualification shall carry a weightage of 10%. My lord, here, these two is important. Oral interview carry a weightage of 30% is important. And work experience and knowledge proficiency 10%. This is very important because this has been changed. Thereafter, the next written examination was conducted on 13/7/2016. Altogether, 56 candidates appeared for the written test.
Where from you are saying? Statements.
My lord, that I have mentioned in my paragraph number, paragraph number 7. I have mentioned in paragraph 7. Yes, paragraph 7 of my declaration I have mentioned. Accordingly, the written examination was conducted on such and such, and altogether 56 candidates sat for the examination. However, written result was not published either in the local newspaper or through notification in any manner. The selected candidates who qualified for the oral interview were telephonically informed in the same evening to be reviewed with all the original documents. Therefore, the selected candidates for the oral interview had no occasion to know the marks secured by each candidate in the written examination. Thereafter, since the petitioners had no knowledge of as to how much he got, how the marks obtained, so the petitioner has applied for an RTI. That is page number 26. Page number 26, my lord. Allow me to read it, my lord. My lord is there, page number 26.
Yes.
Yes, this was to the VIO, Governor Secretary, under right information under Act 2005. Such and such. Number 1, a copy of calling letter. Who said the question paper? Who evaluated the answer script? List of candidates called for the oral interview. List of mark obtained by each candidate in the written test. List of interview board members. Whether written in oral interview or conducted as per the instruction given in the calling letter. That was the question asked on the RDI. And my lord, we come to page number 29. This is the list of candidates who were called for interview.
Yes.
So this is the list of candidates who were called for 13% were called. Yes. And out of these, my lord, out of these candidates, the petitioner secured the second highest mark in the written test. That is in page number 1331. 1331, the petitioner secured the highest.
Where is the respondent?
Respondent is page number.
Petitioner is serial number?
Page number 30, serial number 28. Page number 30, serial number 28. The respondent secured 31.4.
Serial number?
28. Serial number 28. The respondent secured 31.4. 31.4. And the petitioner secured, that is page number 31,
serial number?
36. 36. Petitioner secured 36. This is out of 60%. So petitioner secured 33%, and the respondent secured 31.4%. And here, this serial number 51 is also important, my lord. Here, serial number 51.
Number 51.
Yes, it's page number 31. Page number 31. This person secured the highest 33.9. However, this person did not appear the oral interview. I have made a clear statement on that. So the petitioner secured the highest mark among those persons who appeared for the oral interview in the written examination. Thereafter, if my lord will come to page number 34. My lord, merit of list of candidates in the order of merit. Losi Konya, that is the respondent.
Losi Konya, respondent number?
6, respondent number 6. Academic and professional courses, she secured 12%. But here, as per the advertisement and as per the
this is weightage, right?
My lord, she secured 12%, but that has to be out of 10%. Because as per the partial modification after the advertisement, it was 10%. It was 10%. My lord, I'll come to that. It was 10%. And she was given 12 marks. The petitioner, which is in serial number 3, she secured 5 marks. That is in the academic and professional courses. And the remaining, since I have already pointed out, My lord, I will be allowed to take your lordship to page number 8 of my writ petition. Here I have made a table specifying how it was done. Page number 8 of my writ petition. This my lord there. My lord, the second table, name of the candidates, Dosi Gunya, academic and professional courses, out of 10%. As per the portion modification, also it has to be 10%, but out of 10%, secure 12%. So that is 2% excess. And the petitioner, out of the petitioner as it is. So if that 2% is minus from the respondent's marks, she will be securing only 58.4%, and the petitioner would have secured 59%. That is how the petitioner has approached this honorable court on the ground that the rules of the games has been changed after the game is over.
There is another one, 59.5%, 05. This petitioner's name is what?
Petitioner is needs to know cell number 3.
Who is Ruth K. Chan? She's getting some marks, then more than you. Second, that table itself.
My lord, yes.
Oh, okay.
My lord.
Paragraph 17.
Yes, my lord. He has not secured 100%, 50% of it. So, my lord, the same.
Somewhere it is said where 50% will be called.
Yes, my lord, in the following letter.
Top 15, who has obtained 50% from
Yes, my lord.
us.
In the portion.
Okay.
This is annexed
Okay.
case number 3. My lord, the same has been admitted by the academic of the government, that is respondent number 1, 2, 3, 4, 5.
So after that, what happened? This respondent number 6 was recommended or what?
Yes, my lord, respondent number 6 was recommended and appointed, already appointed.
The appointment letter is 37.
Yes, my lord. The last page. This is the appointment order.
Just a minute.
My lord, may kindly turn to government affidavit, that is affidavit in opposition of 1, 2, 3, 4, and 5. I'll just point out one paragraph here, my lord, page number 3.
Yes.
My lord, the last second paragraph, I may be allowed to read out. The deponent further states that a meeting of the selection board was held on such and such before the written test to shortlist the candidates for oral interview. The selection board felt the necessity to review and modify the marks kept for oral interview to ensure selection of the best from amongst the candidates who were having higher educational qualification and professional qualification from the most reputed universities, work experience, seniority in government service, and method of selection in their existing service, knowledge, and proficiency in computer. Accordingly, the selection board decided that the marks in the oral interview be reduced from 30 to 25%. So the oral interview marks were reduced from 30 to 25%. And the marks for the work experience and proficiency in computer educational qualification were increased from 10 to 15%. This is the change of the rules in the game. So The last paragraph, the decision of the selection board was also displayed in the notice board of the Governor's Secretariat for information of the interested candidates. Now, the question is whether the information placed before the notice board will suffice, can stand the test of this one. The judgment that was referred to the larger page has been decided on 7th of November. 7th of November. My lord, if my lord may kindly turn to page 42, sorry, 42. I'll just read the conclusion as to what the court has decided. 42 conclusions. My lord, very dear my lord, I mean the lord. We therefore answer the reference in the following terms. Number 1. Recruitment process commences from the issuance of the advertisement, calling for application, and ends with filling up of vacancies. 2. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway, though the recruitment process unless the extent rules so permit or the advertisement, which is not contrary to the extent rules so permit. Even if such change is permissible under the extent rules or the advertisement, the change would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness. Number 3, the decision in K. Manjushri Subra lays down good law and is not in conflict with the decision in Subhash Chandra Marwaha Subra. Subhash Chandra Marwaha deals with the right to be appointed from the select list, whereas Manjushri Subra deals with the right to be placed in the select list. The two cases therefore deals with altogether different issues. Number 4, recruiting bodies subject to the extent rules may devise appropriate procedure for bringing the recruitment process to its logical end, provided the procedure so adopted is transparent, non-discriminatory, non-arbitrary, and has a rational nexus to the object sought to be achieved. 5. Extent rules having statutory force are binding on the recruiting body, both in terms of procedure and eligibility. However, when the rules are non-existent or silent, administrative instructions may feel applicable. Number 6, placement in the select list gives no indefeasible right to the appointment. The state or its instrumentality, for bona fide reasons, may choose not to fill up the vacancies. However, if vacancies exist, the state or its instrumentality cannot arbitrarily deny appointment to a person within the zone of consideration in the select list. So this was the decision of the constitutional bench which upheld the judgment led in Manjushri's case.
What was Manjushri? Where is Manjushri discussed here?
My lord Parachi, page
Manjushri,
43. Page 43.
Now, what was laid down by Manjushri?
That the rules of the game cannot be changed.
Now, where it is mentioned here somewhere.
Manjushri's case is laid down the law that the rules of the game cannot be changed. That is how that was. My lord, thereafter, my learned senior counsel was also citing one judgment of 2024, volume 3. This 2024, volume 3 was decided before this constitutional bench judgment of delivering the judgment of this reference. In this judgment, 2024, volume 3, the facts is slightly different from the present facts, with the present case. In this 2024 volume 6 judgment, the judges, the constitutional bench did not feel it necessary to wait for the judgment of this reference court because that was not necessary. And that is how it was decided, number one. Number two, even going by the facts, here in this 2024 voluntary case is something to deal with proficiency, because it was for appointment of district and section judges in the state of Kerala. And in the present case, it is not both the petitioner and the respondent, they have equal experience as LD computer assistant. Because the advertisement itself was very clear that only those candidates who are serving can apply. All of us, we were working in different departments. And by now, the petitioner here is serving as an LD computer assistant for the past 10 years. Even though it's from a different department, she has the experience to hold the post of LD computer assistant. So this 2024 voluntary judgment cannot be applied in total in the present case, because in this 2024 voluntary case, in the state of Kerala, it was for appointment of district and section judge. And the decision of the court was that not to disturb the appointment of the respondents on the ground that 6 years has elapsed and that they have gained enough experience, and that will be not in the interest of the public to quash their appointment and bring in new candidates who are new to the job. But in the present case, it is completely different, because even the petitioner here has the experience of 10 years of as LD computer assistant. So it will not be against the public interest to quash the appointment of the private respondent and place the petitioner in that case. And so my submission is the decision of the reference court in Tej Prakash should be applied to in this present case by quashing the appointment of the private respondent and appointing the private petitioner in that present case.
Please lodge. It seems my friend has completed, so may I? Yes. Well, let's take about the 5 minutes on the facts of the case, then go straight to the judgment, because immediately the judgment will must be decided. My lord, subject to repetition. Annexure C to the writ petition is a petition on 31/11/2025. Lordship may kindly see. The eligibility criteria is mentioned in the terms. One of it has to be divided into two. Advertisement at Manor. So, Manor, the terms is the eligibility criteria starting from one should have a minimum qualification, graduation, and then computer knowledge, and then experience, and one should be an employee. One should be serving in the department in a government job, because it was for serving employees from the 6 tribes from Eastern Nagaland for those. So, my lord, the eligibility criteria is mentioned in the terms. Then, my lord, the examination is the procedure. The procedure for the exam, how the procedure has to be conducted. Now, here it is, my lord, 50 marks for written, 30 marks for oral, and 20 marks for work experience. Because, my lord, you want somebody who have the requisite work experience, because the advertisement is, Lordship, you can see on the top, is from the 6 tribes who are serving the department. So, my lordship, you can make the distinction between keep this in mind, the procedure in the eligibility criteria, because my lord, the reference was with regard to the procedure. Whether some discretion should be given to the procedure, whether some discretion with regard to procedure should be given to the appointing authority or not, that was a reference. That's why, my lord. Then, my lord, next page. My lord, now 50, 30, 20 in the advertisement was further changed to 50, 30, 10 by the calling letter on 8 February 2016. Lordship. 60, 30, 10. So, my lord, the advertisement, the procedure provided in the advertisement was further modified by the calling letter. 60, 30, 10. The petitioner had no grievance in the modification of the procedure. Lordship, that lordship may kindly keep in mind. Thereafter, lordship, the interview was conducted. The oral interview was conducted. And the written examination was conducted. Then your lordship may kindly come to the affidavit in opposition of the state government after Rajpal. However, lordship may kindly go to page 11 and extract 2. Lordship is following.
Yes.
This is dated 12 July 2016. Now, my lord, a selection board meeting was held on 12 July 2016 in the office chamber of the Commissioner Secretary to shortlist the candidates for oral interview based on the marks obtained in the written examination. Decision taken during the meeting of the selection board. 1. On scrutiny of work experience, knowledge, and proficiency in computer educational and professional qualification of the candidates shortlist for a written test. The board, after taking into account the works and experience of special qualification processed by the candidates, is observed that there is a need to review the marks kept for oral interview. And after detailed discussion, it was decided that the marks in the oral be reduced from 30 to 25, and the marks for the works experience, knowledge, and proficiency in the computer educational and professional qualification will be increased from 10 to 15. The marks will be 40% as given in the call letter of the candidates. Because, my lord, 40% is for the personality test in the calling letters. 60, 60, my lord, 60. Yeah, I can give you the final selection of the candidates of the those called for interview will be as under total marks obtained in the written examination of 200 marks will carry weightage of 60%. The oral interview shall carry weightage of 25%. The overall assessment as such of work experience, knowledge, and proficiency in the computer education and professional qualification shall carry a weightage of 15%. 3. The selection members thereafter finalize the marks for the works experience, knowledge, and proficiency in computer education and professional qualification for all candidates. The marks given to each candidate's work experience, knowledge, and proficiency in computer educational and professional qualification is equals. A copy of this decision of the selection board may be put up in the notice board of Governor's Secretariat for information of all of the interested candidates. So, my lord, a day before the oral interview, this decision was taken. And then it was put up in the notice board. Then, lordship, to that extent, lordship, can you allow me to read 2 paragraphs? I'm reading paragraphs 7 and 11.
Yes.
That as to part the statements made in paragraph 28 of the petition, the document state that as per advertisement dated 25/11/2015, the selection process consists of written, oral, and work experience. The distribution of marks as under 100 marks, 50 written, 20 oral, 20 marks for working experience. Subsequently, the total mark was modified and increased to 200 marks, 150 for multiple choice, and 50 marks for objective, and the same was reflected in the call letter. In the call letter, it was mentioned that the top 50 candidates would be shortlisted for oral interview
interview, provided he had obtained a minimum of 50 marks in the written exam. And that the final selection of candidates out of 2 scores for interview will be done as standard, total marks 60, oral 30, proficiency 10. The important further states that the meeting of the selection board was held on 12/7/2016 before the written tests to shortlist the candidates for the oral interview. The selection board felt the necessity to review and compare the marks scale for oral interview to ensure selection of the best for amongst the candidates who are having higher educational qualification and professional qualification from the most reputed universities, work experience, seniority, involvement, service, and method of selection to the existing service knowledge and proficiency in computer. Accordingly, the selection board decided that the marks in the oral interview be reduced from 30 to 25, and the marks for the work experience, knowledge, and proficiency in computer educational and professional qualification be increased from 10 to 15. The marks for oral interview and work experience for 40 persons as given in all letters. The decision of the selection committee was also displayed in the notice board of the Governor's Secretary. Mother, this is what got appointment in rush hour. For information of the interested candidates, however, is
What is this? Notice board?
notice board for information of the interested candidates.
What decision?
Decision of change from 15 from 30 to 25 and 10 to 15.
Yes.
However, instead a both number of candidates scoring more than 50% written, there's only 5 candidates who score more than 50 marks in the written test. The committee, after careful consideration of the mark in this meeting, decided to relax the eligibility criteria written from 50 to 45. But in this case, both the petitioners have scored more than 50. So no issue about that. It will mention here is that as per the Raj Bhavan manual, the equipment of the staff of Raj Bhavan is exempt from the purview of the Public Service Commission. Thus, it is conflict. Freedom to the governor to recruit the staff not be considered suitable. The 11 note.
Yes.
That as regard the statements, the governor reiterates and reaffirms the statements made in paragraph 7 in this affidavit. As earlier stated, the notification of marks was necessitated to select the best from amongst the candidates who were having higher educational and professional qualification on the most reputed universities with work experience in unity in government service and method of selection in the existing marks, knowledge and proficiency number. Moreover, it is important. In fact, the marks for work experience have been awarded to the candidates before the oral interview, and the same was displayed in the notice board. So, my lord, before he appeared, the petitioner then drafted. May I read, my lord? The petitioner, having appeared to the oral interview without any objection, has no right to question the selection process. It is now a well-settled principle of law that if a candidate takes a calculated chance and appears in the interview without protest, because the interview result is not favorable, the candidates cannot turn around and question the process of the selection. The conduct of the petitioner clearly decided is entitled from questioning the selection process. Even otherwise, no credibility has been committed in the case of the previous respondent in the 6th following to the post of secretary or in the following letter such and such. Now, my lord, so that is the facts of the issue. Now, my lord, it is not a case where the respondents were given 12 extra marks. In the work experience, we were assessed from 15. I scored 12 out of 15, and the petitioner scored 5 out of 15. So it is not a question of giving excess marks as claimed by the petitioner and in the table that was shown. Now, my lord, with regard to my work experience, my lord, just to for your satisfaction, the petitioner is a graduate working as LDA, Lord Divisional Assistant, and computer. Then, my lord, in my affidavit in opposition, from page 13 onwards, my lord, the petitioner, the private respondent, number 6, have a master's degree. My lord, page 13 is my graduation. Then page 15 is my degree in MA from Delhi University. Then my computer experience in NXT. Then notion you can see from my work experience from page 17. Initially, I worked as a volunteer, as a counselor for any Nagaland AIDS Control Society Lordship. Then, my lord, annexure F, I was thereafter, my lord, I was appointed as LTA cum computer assistant and order dated April 2011. Then, my lord, thereafter, my lord, at page 20, having been declared successful of the Nagaland Public Service Commission, my lord, I was appointed as a senior inspector in the cooperative departments, cooperation departments. Page 20. Then, my lord, thereafter, having been declared successful, I am appointed, my lord, as early as 3rd August 2016, page 29. And my lord, there is no interim order. And I'm continuing in service for the last more than 8 years, now running 9 years. Because the appointment order is 3rd August 2016, Lord. So, my lord, here is the case where the petitioner, the procedure provided in the advertisement was amended when the calling letter was issued. No complaint. Thereafter, my lord, a day before the examination of the oral interview, the governor secretary took a decision board and it was notified along with the marks. By the time, my lord, the petitioner appeared the oral interview, she was aware that she scored 5 out of 15. And I was aware that I scored 12 out of 15. And when the interview was conducted.
No. After written test, the interview.
That's what I mean. What? My lord, the written test was conducted. As per the Judge Robin's affidavit, that which I have gone through, 7 and 11. What has happened was written test was conducted. Then we were called for interview. And my lord, a day before the written test was to be held, it was decided and notified in the notice board of the Raj Bhavan because by then it was too late for us. Because, my lord, so it was notified that that for oral, it is now, it has been reduced 25-15 instead of 30-10. And, my lord, and when it was notified a day before the interview, in the notice board, the mark scores by the candidates in the work experience was also notified. My lord, paragraph 11.
Paragraph 11 of
The respondents. Paragraph 11, Lord. Respondent number 1 to 6, 1 to 5. Paragraph 11, one of the last 2 lines. In fact, the marks for work experience has been awarded to the candidate before the oral.
paragraph 11.
Yes,
Okay, page 4.
yes, last 2 lines. In fact, the marks for work experience have been awarded to the candidate before the oral interview, and the same was displayed in the notice board. This has to be read along with paragraph 7 and 11. So what has happened, my lord? Changes were made. From 14 now it is 55-15 to get the best person with work experience. So initially in the calling, one not subject to repetition. Initially in the advertisement it was 50-30-20. Then it was notified in the calling letter. And the candidates without any complaint appeared in the written exam in the notification of the calling letter by which the advertisement was amended. The day before the exam, it was further amended and it was notified in the notice board. And in the work experience, my lord, all the candidates were assessed out of 15 marks. And I scored 12, she scored 5. It was notified in the notice board. So when you appeared for the oral interview, you were very well aware how much they have scored in their work experience. And the candidate and the examiners, this is very important. And the examiners also had examined them in their oral my lord, out of, out of 25, out of 25 instead of 30. So, my lord, it is not a case where the examiner, it is not a case where amendment was done, modification was done after the oral interview was conducted. So this aspect has to be kept in mind, Lordship, because that is one, that is, so that way, Lordship, the issue is the minimum eligibility criteria was not changed at all. The procedures were amended on 3 stages. So whether that will affect the case. Now, my lord, coming to the case end. Now, my lord, initially when the writ petition was filed, their only grievance was that I was given 2 marks extra. Then we filed our reply. And thereafter, my lord, in the reply of the respondent, my lord, paragraph 8.
Affidavit of the
Affidavit in reply on behalf of the petitioner to the affidavit in opposition of respondent number 1 to 5. Then paragraph 8.
Yes.
That will become the statement in paragraph 7. However, the official respondent, the defendant takes to state a selection process has not been conducted strictly in accordance with the terms and conditions stipulated in the selection procedure / advertisement and following letter. So, my lord, for the first time, you have brought initially, my lord, in the writ petition, who were changed after the claim was over was not part of the pleadings. But in paragraph 8 in your reply, they have taken a ground that procedure was altered, changed. So that's how my lord, when the matter was heard on the last occasion in 2017, since the reference was already there, my lord, this honorable court deemed it fit to wait the outcome. Now, my lord, I am coming to the judgments. Now, my lord, before I go to the judge, in the reference in the judgments, there are 2 by the same, my lord, 5-bench constitutional bench. The same judges, they have passed 2 judgments. One, my lord, is the present case, that is page Prakash Patak. Now, my lord, Lordship, you kindly allow me to refer to the judgment which is before your watching. Paragraph 11. Hello. No, you are read from paragraph 3. Paragraph 3 of the. Now, kindly allow me to, before I go to, kindly allow me to refer the facts of this case. The facts of the case is given.
Facts of the case, I know.
Yeah, Lordship must be aware of this. Now, my lord, paragraph 3, relevant extracts from the reference order. To have a clear understanding of the scope of reference, the relevant paragraphs of the reference orders are extracted below. Then, my lord, paragraph 11. Thus, the paragraph 11 of the reference orders, my lord, after all the judgment has been referred, my lord, I'm reading the last, where, my lord, where the eligibility criteria are altered, deal with situation where the state sought to alter one, the eligibility of the criteria of the candidate seeking employment or the method or manner of making selection of the suitable candidates. The latter would be termed as procedure adopted for selection such as prescribing minimum cutoffs to be secured by the candidates, either in the written examination or without receipt as was done in Manjushri, or the present case, or calling upon the candidates to undergo some relevant tests to the nature of the employment, such as driving test, such as such. My lord, I refer to this 2001 case also. In Manjushri, if the principle of Manjushri case is applied strictly to the present case, the respondent high court is found to require 13 of the best candidates out of 21 who applied irrespective of their performance in the examination there. In such case, theoretically, it is possible that candidates securing very low marks but higher than the some other competing candidates may have to be appointed in appointment. My lord, in our opinion, the application of principles laid on in Manjushri without any further scrutiny would not be in the position, not be in the larger public interest or the goal of establishing an efficient administrative machinery. Instead, as such and such, well dealing with the equipment of supportive legislation, judges of the Punjab civil high had to deal with a situation where the relevant rule prescribed minimum qualifying marks. The recruitment was fulfilling of 15 vacancies. 40 candidates secured a maximum qualifying of 45%. Only 7 candidates who secured 55 and above were appointed, and the remaining vacancies were kept unfilled. The decision of the state government not to fill up the remaining vacancies in spite of the availability of candidates who secured the minimum qualified marks for challenge the state government defended its decision not to fill up the post on the ground that decision was taken to maintain the high standards of competence in judicial service. The High Court appealed the challenge it and issue an indemnity. In the appeal, this court reversed and find that the force securing minimum qualifying marks in an examination held for the purpose of recruitment into the service of state have no legal right to be appointed. In the context it was held, in case where appointments were made by selection from a number of eligible candidates, it is open to the government with a view to maintain high standards of competence to fix a score which is much higher than the one required of more eligibility. Unfortunately, the decision is to pass such and such. My lord, I'm reading 15. No doubt it is a solitary principle not to permit the state or its instrumentalities to tinker with the rules of the game in so far as the prescription of eligibility criteria is concerned, as was done in such and such. In order to offer manipulation of the recruitment process or its result, whether such a principle should be applied in the context of the rules of the games, stipulating the procedure for selection, more particularly when the change sought is to impose a more rigorous scrutiny for selection requires an authority pronouncing the larger bench of this court. But kindly pause here for a moment. Then kindly allow me, my lord, before I go further, kindly allow me to refer to 2024 pre-SCC. Because, my lord, this judgment came first by the same constitutional bench. Then I'll read the remaining portion of it. That is B.S. Sivanand CD versus.
Yes.
Lordship. Now kindly allow me to go to paragraph 5. Here, on June 2015, the notification was issued by the High Court of Kerala, for which applicants were invited for qualified candidates for appointment of district inspection judge in Kerala Judicial Service. Paragraph 5 stipulates the selection would be on the basis of competitive examination consists of written and legal course. The total marks assigned for written examination was 300, comprising of 2 papers, each carrying 150 marks. General candidates belong to such and such 50%, ST 40 categories, 40%, I'm reading 6. Finally, the notification which was issued by the High Court on 2015, the written test was conducted. On 2000 such and such, the notice regarding notification regarding candidates who had qualified in the written test had came to be published. Following this, within 2017, the revised voice for all the
qualified candidates were conducted on 2017, after the internal voice was conducted, the Administrative Committee of the High Court passed a resolution by which it decided to apply minimum cutoff marks, which was prescribed for written examination of qualifying criteria in the database. So, my lord, then, my lord, kindly allow me to read paragraph 9 there. When the petition was taken up by a two-bench of this court on such and such, a reference was made by the Constitution bench, following an earlier reference made to a larger bench in Tej Prakash Patak. While making a reference to the Constitution bench in the earlier decision, the principle which has been addressed is whether it is open in law after selection process is instituted to change the rules of the game midstream. In that context, reliance was placed on the decision of Kohima judiciary set of Andhra Pradesh. My judiciary case was after the examination was over. The High Court took a decision to impose a minimum aggregate of 75% after the exam was over. So after the whole process was completed, minimum qualifying marks was imposed in Manjushri's case. The view in Manjushri case has been adopted in the grounded principle which has been laid down in that case would run contrary to the earlier decision in state of Haryana, Subhash Chandra. Moreover, in the state of Haryana, Subhash Chandra, what has happened was, as per the rule, the minimum qualifying marks, passing mark was 45. So the High Court recommended all those who have passed, who have secured 45%. But the state government took a decision that only those above 55% only can be appointed, and the remaining was kept unfair. Honorable Supreme Court says that right to be appointed, Honorable Supreme Court uphold that on the ground that the petitioner doesn't have a vested right to be appointed even if recommended. Now, my lord, in that view, we are inclined to take. In the present case, it does not become necessary to rule on the broader constitutional issue on which reference has been made in text Prakash. But the reason why we have come to this conclusion will be elaborated shortly thereafter. And thereafter, my lord, in this case, my lord, on the ground of legitimate expectation, if the case was tried. Thereafter, my lord, the substantive legislation that the person should have the expectation that the exam should be conducted in accordance with the rule, procedural legitimate expectation that the petitioner had an expectation that that process should be fair, without any transparent, without arbitrariness. That was discussed. The lordship, we kindly come to paragraph 46. Here in paragraph 46. From the above discussion, it is evident that the doctrine of substantive legitimate expectation is embraced in Indian administrative law, subject to limitations in its applicability in given factual situation. The development of Indian jurisprudence is keeping in line with the developments in the common law. The doctrine of substantive legitimate expectation to be successfully invoked by individuals who claim substantive benefits or entitlements based on existing promise or practice of a public authority. Therefore, it is important to clarify that the doctrine of legitimate expectation cannot serve as an independent basis for judicial review of decision making by public authorities. Such a limitation is now well recognized in Indian jurisprudence, considering the fact that a legitimate expectation is not a legal right. It is mere an expectation to avail the benefit or relief based on the existing promise or practice. Under decision by public authority to deny legitimate expectation will be a term as arbitrary and sheer abuse of power. The validity of decision itself can be questioned on established principle of equality, non-arbitrariness under Article 14 in the nutshell. The individual who claims benefit or entitlement based on the doctrine of legitimate expectation has to establish the legitimacy of the expectation and the denial of the legitimate expectation due to the violation of Article 14. Then noted, kindly allow me to read paragraph 54. The High Court's decision also fails to satisfy the test for consistency and predictability as it against the established practice. The High Court not impose a requirement of the of a minimum cutoff for the Viva voice for the selection of post of district session judge for 2013 and 2014. Although the High Court justification when analyzed on its own terms, this ruling is not grounded on legality. The High Court's decision to apply a cutoff for the Viva voice frustrated the substantive legitimate expectation of petitioners, since the decision of the High Court is legally untenable and fails in touchstones of fairness, consistency, and predictability. People will hold that the force of action is arbitrary in violating of Article 14. Now, please, what's important for me? What should this court do? The question which now arises before the court is in regard to the relief which will be granted to the petitioners. The final list of successful candidates was issued on 6/3/2017. The candidates who have been selected have been working as district station judge for about 6 years. In the meantime, all the petitioners who are before the court have not functioned in official office. In this lapse of time, it will be difficult to reiterate the unseating of the candidates who have performed the duties, and unseating them at this stage would be contrary to public interest, since they have gained experience as judicial officers in the service of the state of Kerala, where the presence of the petitioner is that if the aggregate of marks in the written and Viva voice were taken into account, he would have ranked higher than 3 candidates who were respondents in this proceedings. Equally, we cannot lose sight of the fact that all the candidates are otherwise qualified for judicial office and have been working over a length of time, and seating them would, besides being harsh, result in a situation where the higher judiciary will lose the service of 2 truly qualified candidates who have gained experience over the last 6 years in the post of district judge. For the reason above, we have come to the conclusion that it would not be possible to direct the induction of the petitioner in the higher judicial service in the present stage. Many of the petitioners would have joined the bar and would have been in active practice. It needs to be clarified that they having failed to gain selection in the higher judicial service, which was initiated in 2015, is not a reflection either on their merits or ability, and shall not come in the way of their being considered for any office, judicial or otherwise in future. Conclusions. The following are conclusions in the matter about this discussions. The principle of good administration requires that the decision of the public authority must withstand the test of consistency, transparency, and predictability to avoid term as arbitrary and violative of Article 14. An individual who claims a benefit or entitlement based on the doctrine of legitimate expectation has to establish the following: legitimacy of expectation, the denial of the legitimacy expectation due to the violation of Article 14. A public authority must demonstrate by placing relevant materials before the court that its decision was in public interest to frustrate the claim of legitimate expectation. The High Court of Kerala to apply minimum cutoff was contrary to rules. The High Court decision to apply the minimum cutoff marks for Viva voice restrict the substantive legitimate expectation arbitrary and violative of Article 14. In terms of the relief, we hold that it would be contrary to the public interest to direct the induction of the petitioner into the higher judicial service after a lapse of more than 6 years, and it is have selected nearly 6 years to book enough is unseated. They were all qualified and have been serving in the district judiciary of the state under unseating them at this state would be contrary to the public interest. To induct the petitioner would need to bring in new candidates in preference to those who have been upholding judicial service for a length of time, to deprive the citizens or his state or citizens of the benefit of those experienced judicial administration as a mere in the public interest. Then in the view which we have taken in the above term, we have not considered it necessary to answer the further question which has been referred to the constitution bench. Besides, the question has been squarely raised in certain other cases which form part of the present batch of cases in which arguments are being held in constitution, held by the constitution. My lord, this was delivered in July 2023. It was decided on 12th July 2023. Thereafter, lordship, the same 5 bench constitutional 5 same judges, my lord, has again passed the reference. Now, my lord, lordship, you can allow me to come to page 12. Now, back to that page Prakashan. I am reading from paragraph 12. Analysis logic. To effectively analyze and adjudicate upon the questions referred, we would divide our discussion in the following parts. A. When the recruitment process commences and come to end. B. Besides cases of the doctrine, the rules of the game must not be changed during the course of the game or after the game is played. Whether the decision in 123 is a variance for the earlier proceedings on the subject, whether the above doctrine applies with equal strictness for method of procedure for selection as it does for eligible criteria, whether procedure for selection stability by act or rules frame under provision of 309 of the Constitution or statute would be given a blue by whether the appointment could be denied by a change in eligibility criteria after the claim is made. Then the basis of the doctrine, my lord, and then my lord, in paragraph 17, the Sivananda case, which I read 2024 360 has been referred to, and my lord, the Manjushri case is in paragraph 18. Merit this, my lord.
Yeah.
In Manjushri, the recruitment exercise was for selection appointed the post of District and Session Judge grade to the extent to respect the eligibility qualification part was silent on the procedure for selection. The manner and method of selection was therefore to be decided by the High Court for every selection as and when vacancies were notified for selection. The vacancies were notified by the state government. As for invitation for selection, everything followed by interview was to be held. By resolution of 2004 by the Administrative Committee, the High Court resolved to conduct written examination for 75 marks, interview for 25. It was also resolved that the minimum qualifying marks are also prescribed. Following the High Court's decision, written exam was held on 2005 and its result was declared. Where 83 candidates were successful, interviews were held on March 2006. Thereafter, the marks obtained by those 83 candidates were accredited and the consolidated merit list was prepared in order of merit on the basis of the aggregate marks. The merit list inter alia contained marks secured in the written examination, marks secured in the interview, and total marks secured in the written examination and interview order 125. Based on that, the Administrative Committee approved the selection of 10 candidates as per the merit date reservation. However, the four did not agree with the selection is prepared. Consequently, the Chief Justice constituted a committee of judges for preparing a fresh list. The committee recommended that in place of 100 marks for written examination, 25 and 25 marks for interview, the candidate should have been evaluated with reference to 75 marks in examination and 25 marks for interview. In line with the earlier resolution of 2004, the committee also recommended that minimum pass percentage upon for written examination to determine eligibility of the candidates for appearing in the interview should also be applied to interview marks and to secure such minimum marks in the interview should be considered certificate. Based on the recommendation, the minimum percentage was applied for interview and only those candidates who secured the minimum marks of such and such were considered for having succeeded in the interview. As a result, only 31 candidates were found qualified to the written examination in consequence with revised merit list of 31 were prepared, whereas candidates selected were ousted for a few others who did not find the earlier less than entry. So, my lord, it's a case where, my lord, everything was changed after the game was over. Now, my lord, thereafter, my lord, also kindly allow me to read paragraph 21. Very important is that the minimum mark for the interview was fixed after the interviews were over. Malak, so then Malak, then what should the carry allow me to read paragraph 26?
Yes.
And most reading of the Subha Chandra disclosure, there was no change in the rules of the K eligibility for placement in the select list that the select list was preferred in accordance with the rule, but since the extant rules did not create any obligation, the part of the state government to make an appointment against all 95 vacancies, this court opined that the state would take a policy decision not to appoint candidates securing less than 55%. With the reasoning that taking into account that appointments were made of top 7 candidates in the select list who have secured 55% or higher marks. This court found no merit in petition of the petitioner. On the other hand, in Manjushri, the eligibility criteria for placement in select list will change after the interview was held, in which had a material during the select list. Thus, Subha Chandra, he would like to be appointed from the select list, and Manjushri, he would like to be placed in the select list, whose cases therefore deal with altogether different issues. Then, my lord, paragraph 27. Marriage. The High Court of Kerala invited application for appointment to the Munsip in Kerala's service. 1,292 applicants were found, only 18 candidates, 118 candidates passed the written. Out of candidates, 18 passed the interview and select list was prepared for among those 88 candidates. Candidates who were not selected asked and did not score the prescribed minimum marks in the interview file with petition contending that in the absence of specific legislative mandate prescribing cutoff marks in interview, the fixing of separate minimum cutoff mark in interview for further elimination of candidates after comprehensive test. Written test touching the requisite subject in detail was violative of the statute. The writ petition was allowed by single judge at the High Court, against which intra-court appeal was filed before the division bench. The division bench set aside the order of a single judge, in which appeals comes before this court. While dismissing the appeals in reduction such and such, then I'm reading paragraph 28. The decision in case which I have just referred in 27 make it clear that if the rules governing procedure, if the rules governing recruitment provide the attitude of the competent authority to devise its procedure for selection, it may do so. It may do subject to the rule against arbitrariness enshrined in Article 47 of the Constitution. Even when magistrate does not prescribe minimum fixing minimum marks for either a written test or interview as an eligibility criteria for selection, one magistrate does is to regulate the stage at which it could be done. This is clear from the decision of the court in such and such a condition was raised that in the decision in K, magistrate should be regarded as a prior inquiry for not having released earlier decision in such and such. Rejecting that, then my lord, this is the issue. Then I'm reading paragraph 29. Merely paragraph 29. The ultimate object of any selection process any process of selection for entry into public service is to secure the best and the most suitable person for the job, avoiding patronage and favoritism. Selection tests and merit tested impartiality and objectivity is the essential foundation of any useful and efficient public service. So open competition examination has come to be accepted almost universally as a gateway to public service. It's now well settled that while the written examination tests the candidate's knowledge and intellectual affinity in an interview test is valuable to assess the candidate's overall intellectual and personal qualities. Well-written examination has certain advantage over the written interview test. There's yet no written test which can evaluate the candidate's initiative, alertness, resourcefulness, dependableness, cooperativeness, capacity for clear logical presentation, effectiveness in discussion, effectiveness in meeting, and dealing with others, adaptability, judgment, ability to make decision, ability to make intellectual and moral integrity. Thus, the written examination assess the man's intellect, and the interview test the man himself and the twine shall be made for a proper selection. What is clear from the above is that the object of any process of selection for entry into public service is to ensure that the person most suitable for the post is selected. What is suitable for one post will not be for others. Thus, a degree of discretion is necessary to be left to the employer to devise its method, procedure to select a candidate most suitable for the post and fit subject to obliging principle enshrined in Article 14 and 16 of the Constitution, as also the rules state of governance, service, and division. Thus, in our view, the appointing authority, recruiting authority, completing authority, in absence of any rules to the dispensary, can devise a procedure for selecting a candidate suitable to the post, and while doing so, it may set benchmarks for different stages of the recruitment process, including written examination and interview. However, if any benchmark is set, the same should be stipulated before the commencement of the recruitment process. But if the extant rules of the application inviting application involves the competent authority to set benchmarks at different stages of recruitment, then such benchmark will be set at any time before that stage is ready, so that neither the candidate nor the evaluator examiner interview is taken by surprise. The decision in him usually does not prescribe setting up benchmarks for various stages of the recruitment process, or mandates that it should not be set after the stage is over. In other words, after the game has been played. This view is in consonance with the rule against arbitrary treatment in Article 14 of the Constitution, and meets the legitimate expectation of the candidates, and as also the requirement of transparency in recruitment to public service, and the third point of clear malpractices in the preparation of the selection. Rules does not apply with equal strictness to steps for selection. Another, as already notified, notice in section A, the recruitment process will realize on basis of various steps like inviting applications, scrutiny of applications, rejection of defective application or elimination of ineligible candidates, conducting examination, calling for interview of giveaways in preparation of lists of successful candidates for appointment. Such subject to the rule against arbitrariness. How tests of giveaways are to be conducted, where what questions are to be repeated, in what manner evaluation is done, whether a short listing exercise is needed, are all matters of procedure which, in absence of use to the contrary, may be advised by the competent authority. Often, interpretation inviting applications are open-ended in terms of this steps and leave it to the discretion of the competent authorities to adopt such steps as may be considered necessary in the circumstances subject to the overarching principles of rule against arbitrariness enshrined in Article 14. Then, my lord, paragraph 32, 33, up to 35 are the examples given. So, my lord, then, my lord, the procedures prescribed in extant rule not to be violated, my lord, the Sivananda case again referred by the text 37. Then, my lord, thereafter, I am coming to the conclusion. 42. Now, my lord, since my learned friend has read the conclusion, I am only relying on, my lord, 4. Recruitment bodies, 42.4. My lord, recruiting bodies subject to the extant rules may be devised an appropriate procedure for bringing the recruitment process to its logical aim, provided the procedure so adopted is transparent, non-discriminatory, non-arbitrary, and has a rational nexus to the object sought to be achieved. Now, my lord, in the present case, the minimum eligibility criteria was not altered at any stage. Only the procedure, how much marks to be given to for what? Initially, the first advertisement, then in the calling letter, it was amended. Thereafter, a day before, it was amended out of 40% of the personal. It is not the case of encroachment upon the marks for written. Out of the 40, it was modified, amended on two occasions to the knowledge of all. That is the issue. So, my lord, to obtain the, so whether it is any arbitrariness or the discrimination, because we all appear knowing well that the personality test will be 15, written will be 25. Because it was notified, in fact, even the marks were notified. Already that in how much a person is scored in the personality test was already notified in the notice board before he or she entered the examination. I was aware that I scored 12. She was aware that she scored 5 out of 15. So, my lord, that is under merit. Now, my lord,
yes.
on the issue of, my lord,
Can you
equity.
shorten? Already put that in.
Yes. My lord, we can complete tomorrow because I'll take another 15 to 20 minutes just to refer on the judgment. Yes, lordship has a very tiring really.
Right. The parties are heard as the hearing remain inconclusive is the case as tomorrow as part heard.
Much better.
For one and other,
Tadi TV ada na.
Kami ini TV. Kita TV. Cuma itu part ada sih dulu. Pas awal jadi. Itu dulu.
Dia lalu. Part ada na.
Isi. Tadi sih dulu. Nah, sih dulu. Itu jangan lebih deh. Single ada ni, jadi benar ni nak. Itu TV lah tu. Mungkin cepat jalan tu nak. Oh, part. Dia. Jadi itu statement dia. Itu kan television.
Budi lada ये रहा है वो. Bell application.
Bela sih. Ya.
हमें तक वापस कंफ्यूज पूरा नहीं मिला. चिंता वो इसके लिए.
Aku mau date masa ini tu, maksudnya, sepinya lagi dah. Itu tu beri uang mana? Lebih ya, macam sih kan?